To order this meeting Wednesday, April 22, 2015. It's approximately 6:30. Tonight, our invocation is by Pastor Dory, pastor of St. John's Episcopal Church. We'll follow by the Pledge of Allegiance by the Police Explorers and Councilman Burgess. Could you all please rise?
Let us pray. Oh Lord, we thank you for this time together. Lord, we thank you that we have the freedom to have these times together. I ask you to bless every family represented by our leaders of the community here tonight. Bless each and every one of them for their time and talent they put in to make our city what it is today. All this we ask in Jesus' name. Amen.
Amen.
Please join me in pledging to the greatest nation on the face of the earth.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. You may be seated. Roll call, Madam Clerk.
Councilman Maldonado.
Here.
Councilman Burgess.
Here.
Councilman Williams.
Here.
Councilwoman Woolman.
Here.
Councilwoman Fairclough.
Here.
Vice Mayor Shelley.
Here.
Mayor Porter.
Here. Item 3 is public comments. You're welcome to come at this time if you have anything you'd like to speak publicly towards. I request that please hold it to 3 minutes, and you're welcome at this time.
Good afternoon, Mayor and Council. It's good to see all of you again. I don't see you that often, so I'm glad to see you. Last week, Palace Assisted Living on Chrome hosted their annual breakfast for the Chamber of Commerce. It's always a beautiful affair. It was a nice day. And at the end of that breakfast, the director was asked for us to pass out and sign a petition that's called a petition to amend the charter of the city of Homestead. Now, I looked at that and I said, proposed charter text amendment. Well, I read through it. And in fact, my wife, Clara Waterman Powell, was on the committee that did the changes to 2006. I gave her this document, and I asked her to explain to me what it read. She didn't know what it read. I don't know what it reads. So I'm very confused, and a lot of other people aren't sure what this is all about, who created it, why are we doing it. Nothing's changed since I see from 2006. And what's the cost of putting it on a ballot? And if there's a way you can explain that to everybody, that would be nice. And if there could be a workshop, maybe some information that comes out, people sign this without knowing what it's about, that's criminal. Thanks for your help.
Good evening. My name is Dr. James Eric McDonough. I live at 32320 Southwest 199th Avenue. Thank you, Honorable Mayor and Council, for the opportunity to speak here tonight. I would like to bring to the attention of the full Council and the good citizens of Homestead some serious matters which need to be addressed. I will continue to address matters of public concern so long as my First Amendment rights cease to be wrongfully and unlawfully abridged by the mayor and the manager. That these violations were made in violation of the city's charter, as well as the rules and policy of these meetings in such an open and public manner, is discouraging to say the least. Respectfully, I'd like to comment openly on some remarks made by the manager at last meeting. When speaking about these victims of abuse, Manager Gretzis basically stated that they had written emails and letters, had filed complaints, and had gone to other law enforcement agencies and even the state's attorney's office, among other avenues attempting to obtain redress. Manager Gretzis stated specifically that no one had ignored them. First, I'd like to point out that these higher level agencies will not take complaints from a citizen. The citizen is always referred back to the original agency and their IA departments. This presents a perfect opportunity for the fox to guard the hen house. It is naive to think there is not selective enforcement against both civilians and law enforcement alike. In honest cases of abuse, Homestead Police Department basically claims nothing to see here. We've investigated ourselves and we found we followed the policy and law. Yet if one actually looks at the policies and the law, these falsehoods are exposed in example after example after example. It is kindly submitted that the manager is not fully aware of even 1/10 of what he has spoken, though he has falsely accused others of doing exactly such. Yet if the manager is aware, then it's at least malfeasance of office. The manager appeared to imply, as none of the other officers were charged, maybe they were innocent or that the complaints were not valid. It is humbly submitted, if this is the position of the manager, then with his legal background, he should be able to see the logical fallacies present. It is to be understood, as has been explained by the Honorable Mayor, that the manager is a biased spokesperson with regard to his employees. Given this reasoning, one could understand that if the chief of police were involved in a criminal conspiracy to cover up crimes, then charges would not likely fall on the guilty officers. Surely if I accused Chief Roll of such actions, it would be labeled slander. So please listen to Chief Roll's words in his own words.
And they went down with Magudo because this guy nasty him. Got to the point where you end up getting yourself arrested. And then
Because he lied.
yeah, I know, but I'm saying, it just too much stuff happened. And right now, it's at a point right now where if you want to pursue this and file suits and everything, this city's gonna have some problem based on what you telling me and what you're showing me.
Oh, yeah.
He did some homework.
Chief Roll is present, so if he would like to defend himself at any point, I would welcome this. Where are the documents I gave you, Chief Roll? The manager must welcome this also, based on his previous objections and in the effort of open government, keeping everything in the sunshine. What I'm concerned about is how Chief Roll could pivot from this statement to at least concealing the evidence given to him, and then placing a document in the IA files concluding that my evidence is false. Acting with a corrupt manner and intent to falsify the public record, to conceal public records, or to obstruct the transmission of evidence relating to the commission of a felony that directly affects one's agency is official misconduct under Florida Statute 838.022, Section 1, paragraphs A, B, and C. This is 3 separate third-degree felonies.
Okay.
I guess since my time is up, I'll go ahead and step down. I just want everybody to know that if you would like to, you can go to my YouTube channel and you can see my YouTube videos where I've laid out the clear evidence of Chief Roll's felony crimes. Thank you. Have a good night.
Thank you. Anyone else at this time? Yes, sir.
Good evening. My name is Michael Sanchez. I'm a Miami-Dade college student. I volunteer with a group called Homestead Equal Rights for All. It's an organization to liberate and empower the undocumented community. We're an immigrant youth-led organization with students and alumni from Homestead Senior High School and South Dade and Miami-Dade College, and therefore we are very connected to this community. Now, we are an organization which fights anti-immigration legislation, racial profiling, and collaboration of local law enforcement with ICE, Immigration Custom Enforcements. Now, on March 2nd, 2015, ICE Custom Border Patrol came to the house of my partner and I, and they were looking for a family member. At that time, we were waiting for the plumber, and so my partner's mother had opened the door, not knowing it was Custom Border Patrol. And so once Custom Border Patrol presented themselves, they entered the house without a warrant, arrest warrant or search warrant. What they asked us was to show for identification, seeing if we were undocumented or not. They each took us one by one to their rooms to find our identification. After that, they sat us in the living room where they told us to stay quietly. And so they took my partner's sister, her name is Gloria Carrata, and they took her outside, harassing her to find this family member. They harassed her to the point where they said, if you do not tell us where your family member is, then we will take your baby, we will deport your family, and this has traumatized her very severely. Throughout all this, it was very hard to see this happen in my own community because I'm not the only victim, and my family and my partner's family is not the only victim. This happens on a daily basis. Even just today, we've seen Custom Border Patrol in the area, and this needs to stop. This needs to stop. And thank you. This is all I have to say. Thank you.
Thank you, sir.
Good afternoon, everyone. My name is Saul Aleman, and I'm undocumented. Like Michael said, I'm also a member and co-founder of Homestead's Equal Rights for All, an organization which is the largest immigrant youth-led organization in the state of Florida. We have over 2,000 likes on Facebook, and we can reach up to 60,000 people per post when we are able to promote it well. On March 22nd, one of our members, Armando Carrada, on March 22nd, one of our members, Margarito Cruz, sent the entire city council and Mayor Jeff Porter an email of concern inquiring on what the relationship between the city of Homestead is with ICE. We'd never received a response from any one of you or the mayor to which these concerns were addressed. However, we did receive a response from Commander Aquino from the Homestead Police Department, and we want to appreciate him and the police department for responding to our concerns and for being very transparent with us throughout the process. Commander Aquino stated that the Homestead Police Department does assist Immigration Customs Enforcement and Border Patrol in operations when requested to arrest, detain, and separate families if it is an emergency. My question to all of you council members and to the mayor is, when is it okay for a family to be separated from their children? That's my question to all of you, as well as the collaboration between ICE and our local law enforcement has instilled and continues to instill fear from our community to report crimes, police harassment, and has created great mistrust in our community. We want to restore that trust, and part of that will come from a meeting in which the conversation is about talking how we can cease the collaboration between local law enforcement and Immigration Customs Enforcement, since there is no law that states that it is absolutely necessary and lawful for that collaboration to exist. It is not anything else but a request between ICE to local law enforcement to help them in the operations that they have. And to end on that, I want to ask each of you all, as an undocumented immigrant who has lived here since the age of 3 years old, I graduated Southeast Senior High School with a 3.7 GPA and have graduated Miami-Dade College as a Pi Theta Kappa member of the Honor Society, and I'm going now to FIU to get my bachelor's in accounting and further my studies at law school. My question to you all is, we want to have a meeting with you all to discuss these issues. We're very thankful to the police department for responding to that email and that concern, but we want to have a meeting with each of you all to be able to discuss how we can build that trust again. And so I want to ask that question, is that possible for us to have a meeting with you all? So I see Councilman Patricia, by the way, happy birthday. I heard it was your birthday not so long ago. But all of you all, is it okay for us to meet with you all? We're very concerned young advocates, and our families are very afraid.
Mr.
So
Williams?
thank you all for your time. And if anyone has anything to comment back.
Mr. Williams?
Thank you so very much, Mayor. And let me have your name again, sir.
My name is Saul Aleman.
Okay. Let me say this in this particular way. On the response from the police department. And I think I share my sentiments with the city manager on maybe last week, George, about this issue, that in me reaching out to you all, that I will be willing to try and engage the federal congressional persons within Homestead, that it's over Homestead, because I think a lot of this is a federal issue, and we're really, kind of not have jurisdiction over that issue. But I have no problem in meeting with you or any one of your coalition. The letter that was sent down I was not giving any input into the letter or the response. Let me say that in that way. Not to dismiss what they were trying to do to answer your questions, but I was not a part of the dictation of the letter or response to it. And so what I have asked the manager and to do is that to bring those congressional persons that deals with immigration to host it at FICO Williams in the very near future to address some of your concerns that's beyond our local municipality. And so I'm willing to do that and to make that contact so that you can be heard. And then the answers that you have, or the questions that you have that we may not have the answers to, the appropriate persons will be there to give guidance. And so I'm willing to do that. Is that not what I said, George, with you? And to facilitate that meeting so that your coalition and others that continue to have your charge and your energy to find a resolution to your issue and not dismiss what you're saying. So that's my stance on it. That's what I'm going to do. And so I can't answer all of your questions tonight, but I will be one of the persons to facilitate the conversation.
Thank you for that. Thank you all for your time.
Mayor, my button's not
Maldonado.
working. Yeah, so I actually received that email, and I was the one who ended up forwarding it to our Aquino, which is on the command staff, and was thankful for the response. And I guess my goal was to at least get a position from our police department and how they're handling it. And so I'm open to meeting with you as well. And also, I'm the liaison for the Community Relations Board for the City of Homestead. And so one of the items that we've been working on within that board is in regards to immigration. We know that it's a major issue here in the United States. So we're aware of it, and it's one of the issues that I brought forward when I took on this committee. I said, let's look at the core issues that are that are before us here in the city, and obviously immigration was one of the key issues that we said that we're going to tackle, work on. On my board, I have an actual representative from the Department of Immigration on an administrative level so that we could have dialogue. And so if there's any questions that you'd want to answer, I guess we can invite, and my chair is here, Terry Weinstein, for the Community Relations Board. You can reach out to her and maybe get you on the agenda and come over. And the Community Relations Board is there to help any issues in regards to the community. However we can help, that's what that committee is for. So we'd invite you to come out and meet us. And so whatever we could do to help you. I mean, we understand this community and how it's been built, and the migrant community that's been here way before any of us probably that's up here. And so we're not blind to our residents and the makeup of our residents. And I think we've always been aware and attentive to everyone's cares and concerns in regards to immigration. So don't feel like you're being dismissed or that you're falling on deaf ears, trust us, we've been working with this for many years, even before my time. And there's many other great leaders here in the community that have been fighting for many years that we'd be more than happy to get you involved in as well. So you could kind of take a glimpse from what, all the work that they've done as well. So again, we'd invite you to the Community Relations Board, see Terry Weinstein, and again, we'll set up a meeting and see what else we could do to help you out.
Okay, thank you. But just to make sure, that seems like so far I have 3 council members interested in meeting with me. Councilwoman Fairclough, Councilmember Maldonado, and I can't read the last one, but
Williams.
Thank you, Councilmember Williams. Thank you all for responding to my concerns. As for the other council members, I welcome you all to the conversation as well. I believe that it could be a positive one, and thank you for your time.
Let me just say, there's on the city's website, each one of us have contact information at our offices in the city hall. We don't necessarily always sit there, but there are staff to answer those phones, and those staff members will coordinate those meetings for us. So that's really the best way to get everyone's schedule worked out, because we'd love to sit and meet. So we just got to, it's got to go through the proper process so that we can be made aware to come to the meeting. So each one of us have that. Ms. Wallman?
Yes. I was going to suggest perhaps if Councilman Williams is heading up this meeting at FICO Williams, perhaps we could notice that meeting and do a little workshop, and so that we could all meet at the same time and hear your concerns. It's a suggestion, but I think it might be a good suggestion to do, or even through the Community Relations Board through Councilman Maldonado, whichever is appropriate. But of course we want to meet with you. But we don't have a lot of information because it is, our jurisdiction is very limited. So, but we're very concerned. So that would be my suggestion, and Mayor, I guess it would be up to you to decide. Councilman Maldonado, okay. So maybe we could notice that meeting and we could all be present and hear what, and then Mr. Williams, I'm sure will bring his people to the table as well, and it could happen all at one time, rather than, everybody trying to make a time convenient for somebody else. So I think that might be a good idea. I'm very anxious to do that.
So thank you, Councilmember Waldman. Yeah, I knew that the conversation didn't end here, and that it was about me addressing my concerns for my community as well as us. I look forward to hearing from all of you as to when that meeting will be and that workshop we could have, so we can begin this conversation, and so we could show you all the work that we have done, as well as you could show us the work that you all have done. Just because I know that we all have our hearts in the right place as well as our minds, and that we have to always remember that this is a country built on immigrants. So that's all I want to comment at this point. But thank you all for responding to my comment, and I'll yield my time.
Mr. Williams, then the manager.
Let me be in order, because I don't want the Community Relations Board to feel that I'm projecting myself ahead of them, because, so under sunshine rules, I don't mind working with Councilman Maldonado to co-facilitate this with his board. And we've been dealing with this quite some time. We even went to California, how many years ago? 2 years ago, trying to help undocumented citizens to even get a card to open up a bank account. So we've been in this process a long time, so this is nothing new for us other than the follow-up. And so we had a consortium of persons to travel to California to see how other municipalities were handling it. And so we were able to get those ideas. And so I think now we need to come back to the table and say, well, this is how we could facilitate it, because it has to do with partnership with banks that we are affiliated with that will use that type of ID, municipal ID, to open up. Am I right? Am I speaking out of term, Jones?
No, you're right. Correct.
So this is not a new issue that we have just brushed under the rug. along with myself and Councilwoman Fairclough and other persons on the staff with George, went to California to seek out directions on how we were going to handle this. We understand that Homestead is 65% Hispanic, and we recognize that. So don't ever think that we sitting up and don't know the issues that is prevailing with your concerns. Thank you, Mayor.
Mr. Manager, and then Mr. Maldonado.
Through the mayor, to the manager, do you have any minutes or notes or anything that we've done in the past in regards to immigration with the city? I know that, and maybe you and the council have been here older. I know we have our organizations that are here that always help out, but have we had this issue discussion in the past? And I know that we've had this issue in the past. I just don't know how we were addressed. But we've always seemed to calm the fears of our residents, and we make them aware that we're here for you. We're not against you at any time. And so I don't know if there's any notes or any meetings or minutes or anything that will kind of help us on that. Thank you. Oh, no.
Can I
go ahead,
for a quick
Yes.
second? I think under Mayor Roscoe Warren several years ago, before he retired, I think maybe 2006 or 7, somewhere, that there was a resolution passed from the council at that time to deal with this present issue. So this goes all the way back to previous administrations that we've been dealing with, and I vividly remember that because I was at that council meeting before I was elected. So, I think there is a resolution.
Okay.
We just have to find it within our history.
Mr. Manager.
Sure, Mayor, I'm sure the clerk would be happy to pull those records and submit them to you. There's really two distinct issues here. The one is how our local police department interacts with our residents and how the federal law enforcement deals with them, and then also the cooperation or non-cooperation between the various jurisdictions. I think it would be important, and the chief has agreed to help coordinate this, councilman, with your meetings, councilmen, because we've had at least one meeting with federal authorities where they kind of explain what they're doing, and certainly some of the things they told us are more confidential in nature, but we're hoping that we can do is at least have them explain why some of this is happening, what their rationale is, and at least information. I think the more information people have, the better they'll understand what's happening. And also having them hear from residents as well, I think would be helpful. And not only, Chief, I think the representatives from the law enforcement community, but some of the elected representatives as well, I think would be helpful for them as the the supervisors of those employees, the checks and balances for them to at least hear what residents are experiencing as well. So this has been an issue that we've been dealing with for a while, and like most of you said, the bulk of it is a jurisdictional problem, but the more dialogue we have, we think the more helpful that will be.
Okay, very good. Yes, sir.
Yeah, Walter Dawson, 29510 Southwest 180th Avenue. I've got some property on Southwest 142 Avenue and Northeast 2nd Street, and I've been ticketed by code enforcement for rats and snakes in my 6-acre tree farm. I've been here before about this, and I've met with the code enforcement officers and had to educate them that right-of-way behind the Umbria development there, it's their responsibility to mow their 25 feet of the right-of-way. My right-of-way is mowed, and it's 12 feet high and full of rats and snakes. I just cleared it again a couple weeks ago, and they're still throwing their toilets and mattresses and toys and their garbage and their tree trimmings over the fence into the right-of-way. And one code enforcement officer, Rodriguez, passed it off to another one, and then he came out and said he would send a truck out there to clean up the mess that I piled up everything, and nobody's ever come out to do that, and now I just cleaned it up again, the rest of the debris and stuff from my neighbors. But, how do you get your code enforcement people to do their jobs and follow through?
Captain, Kent, you want to come up and respond? Or? I'm sorry, you just want to meet afterwards? Okay, I just saw you raising your hand. So. Okay, she's the... Okay. Okay. She's the captain in charge. Okay, thank you. Anyone else?
Mayor, if I may.
Ms. Fairclough?
Captain Kent, after you facilitate that meeting, if you can please follow up with me on what occurred afterwards, because I represent that district. So it's very important for me to be plugged in into what's going on there. Thank you.
Yes, ma'am.
Good afternoon. My name is Mayra Rubio. I am currently the program director of Homestead Era. We've been organizing for 3 years now. I am undocumented as well, and I've been living in the community of Homestead almost all my life. We understand that this is a federal matter, but we also understand that Homestead Police does have a say and a stand on how they work with ICE or Border Patrol. We also understand that there's no way we can control Border Patrol coming in here because we just saw them here today right next to Miami-Dade College. But we ask that our people be treated with respect and dignity because we are human beings and that is what we deserve. The same day of the incident of what happened to Armando in his house, the person was taken away by Border Patrol, and at the same time, another undocumented man was taken, and he has a clean record. He had no warrant, so there was no reason for him to be taken. So what we want to see out of this is how we can work together to make sure that the Homestead Police takes care of those undocumented people in this community, like myself and my parents, who have a clean record, who put money into this community. So that is what we want to take out of here. I want to tell everyone to remember that we are all products of migration in one way or another. Our hands have worked the fields, our hands build things here in Homestead, businesses, homes. You know, we work really hard sometimes under tough situations, under the sun. You know, you only have one lunch break. We want people to remember that we are a huge part of this community and that we deserve respect. So I look forward to working with you all and having the conversation. We know that a resolution was passed before, I think about 2007. We Count, which is another organization here in Homestead, has come to the council meetings. But as of now, we have not seen any positive changes so far that we know of. So we want to make sure that if we do have a conversation, it sticks. We make sure that our community is safe. Thank you.
Thank you. Okay, I'm going to close the public hearing at this time. Public comments. I'm sorry. Excuse me.
Evening, gentlemen, council members, and ladies, I'm sorry. Last month's meeting, I'm sorry, last month's meeting. My name is Matthew Oakey, resident of Homestead since 2000. At last month's meeting, the public comments decorum policy was on the agenda to be voted on, even though it had been previously brought up at the committee of the whole and unanimously accepted. It was put on the agenda to be voted for, and never was voted for. But I notice it's on the viewers here for the gallery.
James, it was voted on.
I sat there and watched the entire YouTube video. You skipped right over that whole section.
It was on the consent agenda. That's right.
Maybe explain.
James, would you explain what the consent agenda is?
Yes, the item is on the consent agenda. On the city council agenda, the beginning of it, there are items that are consent. And those items are items that don't necessarily need a public hearing. They're resolutions which memorialize the council's intent with regards to certain matters. In this particular case, the item was approved by the council under the consent agenda. If a particular council member wants to pull an item for discussion, the item is then read aloud and a public hearing is held on that particular item. But that was not the case at the last meeting. It passed under consent.
nobody that was present at the meeting ever had it. Well, actually, several people at the meeting stood here and made comments about it to the negative. If you ask me, that should have been enough for somebody to step up and pull it for public comment. And I'm looking out at the gallery at all these scary people still working on that issue with the knives, because we do have the lawsuit going forward with Florida Carry and the preemption over the definition of what a weapon is for Homestead, because Homestead still seems to want to consider a folding pocket knife a weapon. Are we going to do anything with this, or it's just the way it is?
It's passed. So it's passed. What was the address, Madam Clerk? What was his address, Madam Clerk? Okay. Okay, you didn't give an address then, just your...
My address?
Yes, sir.
I'm at 100 Northeast 6th Avenue.
Okay.
Number 706.
Thank you.
So this public comment decorum policy gets implemented without ever having any input from the actual public that you're trying to rule over. Is that what I understand correctly?
We had a committee of the whole.
There was Mayor, Council, there was a committee of the whole meeting where you all held a public hearing for discussion, where you all direct staff to place the item on the agenda. Anyone who had any issues or any comments or concerns regarding that item had the opportunity to make those comments during the public comment section of the agenda. So,
and when was that, sir?
That's this portion of the agenda that you're speaking at right now, sir.
The point in time, the date for which you're speaking of, when was that? Was that the last meeting you're talking about? Because you had already voted on it as a whole. The council of the whole had already voted on it, unanimously accepted it. We've been coming to these meetings for 6-7 months in a row now. It's never been brought up for public discourse.
Yeah, I'll have to, the 10th. Yeah, so
March 10th.
March 10th.
That was the committee of a whole. That wasn't the council meeting that we're all sitting here at.
Yeah.
Was it published in one of the local papers that we're going to have this discussion?
Yeah.
Really? I guess I'll have to go to the Herald or the Sentinel and find that issue, because I never saw any of it.
Well, the meeting was published. All the council meetings are advertised, not necessarily
This
in
meeting.
This meeting is
The
published.
meeting that you're talking about, when it was put up for public comment, what date was that meeting? You're saying the 10th. March 10th. That's not a regular city council meeting.
It's a committee of the whole meeting, which is a regular council meeting, but it's a committee of the whole meeting, where official action is not taken, items are discussed, policy direction is given, and the item is then scheduled for the council meeting where official action may take place.
So at the meeting where official action was taking place and it was on the agenda to be discussed, it was never discussed, is my point. That's what I said to begin with. It was on last month's agenda, you went right over it, never said a word about it, and now you're saying, oh, well, that was in an area called consent, and if nobody said anything about it, we just move on and it's accepted. When people at the meeting last month saw it and had questioned it and had made comments in the negative about it.
It's just a policy. It's guidelines. I, as mayor, have never used this decorum policy to shut anyone up, it was just simple guidelines for the public to know what the parameters are when it comes to public discussion. It's not the first time that a decorum policy has been implemented. We referred to Miami-Dade County, we referred to other municipalities, and it is a guideline for the proper way for us to hold the meeting. That's all it is.
I understand. Robert's Rule of Orders doesn't work? That's not good enough for you guys?
I don't think the majority of the public reads Robert's Rules of Order, so it just gives.
Well, the majority of the
additional
public doesn't read the First Amendment and understand that either. Do you guys understand the concept of prior restraint? You can't make a policy that says we can't say slander. Anybody can come up here and say whatever they want. If they happen to slander somebody, it's that person's responsibility to sue this person for the slander. You don't make a policy that says we can't slander.
Okay. Okay,
Not that anybody wants to slander to begin with. The point is to state fact. But you can't make a policy that outright provides for prior restraint. It's a legal concept. The city attorney should know that. It's a matter of the wording of the policy, of the decorum policy.
James, and then we got to go.
Mayor, I'll just say for the record, the policy that you all adopted is not in violation of the Constitution. It's not a prior restraint on anyone's First Amendment free speech. Anyone can exercise their right, free speech rights. This policy is meant to maintain order and maintain decorum through the meeting, to alleviate any disruptions or disorderly conduct. And to that extent, what you've done is completely within the parameters of the law. And across the state of Florida and across the country, many jurisdictions have decorum policies very similar in scope and nature that you all do. So you're not reinventing the wheel. You're simply following what many other jurisdictions throughout the state of Florida and country do, for that matter.
And because everybody jumps off a bridge, that makes it right.
Okay.
Just because many other districts and municipalities are doing something that's not right does not make it right for Homestead. And I'm not talking about saying we can't have boisterousness, we can't have, people fighting in the gallery and, rushing the stage and such. Of course we don't want that. But the month prior to this policy being put up, that is exactly what happened. Was one of the people standing here making comments was shut down from making his comments that were negative about a city employee. When 10 minutes before him, somebody was standing up and giving accolades. How do you allow accolades but you don't allow somebody to give negative comments?
Okay, we're on total different sides of the world here. I don't think we're going to resolve this in this discussion. So we need to move on.
Yes, Mayor.
Okay. We need to move on. Thank you. Anyone else? Okay, I'm going to close public comment. Any additions, deletions, deferrals, manager? Tab consent agenda.
Move it,
Is there a
Mayor.
motion? Moved. Is there a second? All in favor?
Aye.
Okay, we're going to, if there's no problems with the council members, Mr. Williams has to leave early and has requested us to move item 18 and item 20 ahead so he could leave. Is there any objection? Seeing none? Tab 18, Mr. Manager.
Our Assistant City Manager, Kate McCaffrey, is going to handle this item, along with our attorneys.
Yes, Mayor. This is a resolution of the City Council of the City of Homestead, Florida, approving a contract for the sale of real property for the sale of approximately 4.64 acres located at 111 South Homestead Boulevard and known as the Bowling Alley property to RT Automotive LLC, authorizing the city manager to execute the contract for sale of real property and closing documents, providing for implementation and providing for an effective date.
Questions from council?
Question? You said questions, man?
Yes, sir. Mr. Williams?
Okay.
Mayor, we were hoping to start it off with staff report or...
Okay, I'm sorry.
Yeah.
All right.
Kate, staff
Thank you,
report.
Mayor and council. As directed by council at both the March 10th and the March 18th meetings, city staff and the city attorney's office has followed up with Mr. Rivkin in an attempt to come to terms with the contract. And there are still some outstanding items for which there is no agreement. The first of which is the purchase price. Staff had recommended a purchase price of $2,319,000 $1,482, which essentially makes the city whole with respect to the city loan to the CRA, including interest up to this date, April 22nd. And the offer on the table is $2,270,000. The second term, for which there isn't total agreement, is the language in the HUD terms. And the third is paragraph 14, which is essentially control of the property. The city had included a no transfer period of 7 years, and if the property was transferred in those 7 years, there would be a transfer fee of $250,000, which the potential buyer would like omitted from the contract. And the next item is the completion of construction. To summarize, the terms that have been agreed to is that if this contract is signed, the buyer would have 150 days to obtain a dealership license. And after obtaining the dealership license, he would have 10 days to start the development and zoning approvals, and would have 10 months to complete that. And during that time, if it's not completed in that time, which would be a total of 15 months, then either party may cancel. So when that process is completed, that's when we would close on the property. And once the city closed on the property, the buyer would have 4 months to obtain permits and an additional 14 months to complete construction, or TCO or CO. The issue for which there is no agreement is the city had included a $250 per day fee in the event that either the permits or the construction wasn't completed in the allotted time. And the final item for which there is no agreement is the city had included a covenant running with the land for 7 years that the property would be used as a new car dealership, and the buyer would not like to have that deed restriction.
Mr. Williams.
Thank you, Mayor. Mayor, I'm going to take a little time with this, with my responses, and so I'll ask that my colleagues indulge me in because I have prepared a complete document on this bowling alley issue. I think mine's bigger than yours, Kate. Let me first say that, and let me just give a history because I think that's very, very important. Number one is that the request for qualifications that the city did back in January 2009, that the city objective in selling the property is to achieve a maximum sale price for the property to encourage commercial and retail development at the property, to encourage commercial and retail development. And the city intent is to sell the property, and the city will not assist in or providing finances for acquisition of the property to the proposed buyer. That was in '09. Then, two, there was an invitation to negotiate in June 25th of 2010 the sale of the former bowling alley. And the objective in selling the property is to the same thing that I read before, and its desired development to the city to envision that the property be given consideration to its location and importance to the city at that particular time. Which was the Kaufmans who offered a sale price for $3.1 million to be paid over 10 years. Then there was another Florida Comprehensive Educational Facility offered a purchase price of $1 million to be paid over 6 years. Then we went on, we had, and back in 2011, we had a memorandum to the manager, and then of January the 11th, the city council had a workshop. In January the 11th, 2011, the city council had minutes that we had passed. And there were two proposals. One, again, was from the Florida Comprehensive Education Facility and the Kaufmans and Son LLC. Those, you can find those in the Cal minutes in 2011. Then four proposals, one that was submitted in 2012 and was later submitted, presented to the council by B&B Bowling, AKA Strikes at Boca, made two proposals, one to buy the bowling alley and the other to rent it with a future option to buy. Lease purchase of $1 million, total 10 years, $8,333 a month, with the option to extend or purchase for additional $700,000 at the end of the 10 years. Then Bird Bowl Investment, aka Bird Bowl, made a proposal to buy the facility, offering purchase price of $500,000. Then there was Zephyr Commercial Real Estate Group, aka owner Johnny, made a proposal to buy the facility, offering $800,000. And then we had KS Family Trust. I mean, we have gone on and on. This is going all the way back now to 2013. We tried to work a deal with Elite Realtor Estate Investments to purchase the Bowling Alley site, approved by Elite Real Estate Investment up to a vote in December 18, 2013 council meeting. The city received a proposal to buy the Bowling Alley site from Allen Investment. Offered purchase price was $900,000 plus 22% interest of the sale, and the facility was sold to that. That didn't work out. Then January 2014, we had a meeting, and the request for RFP went out. RFP 201411, introduction to city objective to develop property of the bowling alley. The city's intent is that the facility be operated as a bowling alley for a minimum 8 years, securing by personal guarantee. And that did not work out. So back in June 2014, the proposal included two. Option one, $500,000 at the closing and personal guarantee, bowling for a period of no less than 8 years. And option two, $800,000 at the closing, no personal guarantee and no guarantee of bowling. The applicant at that time withdrew the application. That's the history, and that's why we're here today, right? And so now we have a proposed, I'm sorry? Okay. Now we have a proposed buyer who has made a firm offer at 2.1. And the council at that time decided to go into negotiations. Now this property, this bowling alley property, back in 2007, the staff recommended that the Board of Community Redevelopment Agency approve a loan from the city of Homestead to the CRA in an amount of $2 million to be used to acquire and demolish the shotgun houses on Lucy Street. The city agreed to make the loan at the city council meeting on June 18, 2007. The loan will include a 4.5% interest, which is slightly higher than the average of 4.21, and return to the city would receive its funds had remained in the pool cash account. The loan will be repaid out of the proceeds from selling of the bowling alley when it occurs. The bowling alley, at this time in 2007, that means that this bowling alley has really been up for sale since that time. The appraised value of the shotgun houses was $1.9 million. An additional $50,000 would be used to pay anticipated costs of closing and demolishing of the shotgun houses. At that time, we had sold it to Homestead Acres of 866 LLC that acquired the shotgun houses. That was in July 2014. At this point in time, what my colleagues, and I heard my colleagues very well, in saying they want to make the city whole. When the city gave the CRA the $2 billion or loaned it, it was a $2 million with interest. And so what I see happening is that there are a potential deal busters within the life of the contract. And if we were to sell the bowling alley, these are the assumptions and questions that that the bowling alley property is to be sold to a private entity and was remodeled and open or demolished, something else is built on the tax roll. What the total amount of the property tax is that the property owner would pay, assuming that the property is assessed between 1, 2, 3, or 4 million, and I think it's assessed around about 2. The property will probably be worth about, with tax value, at about 50 grand or 55 grand a year. That will go back into the city's coffers. My, my concern is within the life of the agreement that is proposed as the bowling alley and making the city whole. I know that they've had some real intense negotiations, and I think that we can reach, and I'm willing to ask if making the city whole is at $2 million. The buyer is proposing to pay $2.27 million plus the real estate costs to the broker, the commission costs with an excess of $100,000, plus the dock stamps, plus all of the other items that we have asked him to do. And so I think over the time, it will come out, the price will actually come out to be about $2.4 million, which is $97,000 over the appraised value of $2.3 million. The issue that I have is with the HUD. The HUD issue, and you all may have those in your package. I'm really concerned about the last letter from HUD, which indicates that if the city made this deal, let me go to my letters. If the city of Homestead received a direct CDBG grant from HUD and formally closed out the grant in 1999/2000, the city at that time was not an entitlement community at the time of the award. So we would consider Homestead, the other recipient, which is referenced in the state statute, as such that the national objective requirement and the change of use provision at 570-502 were applicable for the period of the grant for 5 years. So if the grant closed out in 2000 and we're in 2015, that's over 15 years ago, right? So after 5 years, after 2000, then from the first part of it, then there's a second clause in there that says through 2004/2005, after that period, the property was no longer subject to any CDBG requirements. That's what the letter says in your package on page 2. That is the most recent letter that we have dated December 22nd, 2011 to Lillian at Y. Sirota Healthman. If that is the case, how can we impose HUD restrictions when the time has lapsed for the city, if it sold the property, they have answered us in a letter that says that the property is no longer subject to any CDBG requirements. So how can we allow this HUD piece to be attached to the buyer? He's really paying full price for the property when you include all of what I have just said. So then what I did, I went further. I asked the attorneys to give me their interpretation of all of these letters. You should have 4 letters. And so what my problem is that when I went back to HUD and I did some research, at this present time, the bowling alley is really considered almost abandoned property. There is there's no retail going on, there's nothing. As a matter of fact, I talked with the manager about cleaning it up. It had grown all kind of shrubbery around. There are vagrants that are living there. They've broken in several times. And so it is really considered slum and blight. And so how can we impose this in a contract when Homestead and the city is not under the CDBG dollars and has passed its time? That's number one. The other issue that I foresee with this contract is that when we ask a person to make us whole, are we including the dock stamp? Are we including all of it that he has to pay to the city to make the city whole? That's question number 2. My third question deals with the contract in paragraph 13 that, or I should say paragraph 14, that is discussed that the first 7 years will be reduced to $250,000 by the city. And so as a penalty, if Mr. J or his company decides to transfer the property, it is my understanding that with Hyundai, they have a more restricted condition, which it must stay a Hyundai dealership for at least 10 years, which is a little bit more restrictive than what we have placed on in our contract. The next problem I have an issue with within the contract is that the 18-month schedule, or assuming 4 months for building permits, who controls the building permits? Who controls that? Could staff give me some direction on that?
In terms of the review and approval?
Who controls the building permits that is applied for?
Well, the applicant will apply, we'll review them and approve them and then inspect. Our staff.
And how long is that process?
It depends on the quality of the plans. It takes a couple weeks to review the plans, to issue the permits, and then once they're done constructing, they'll call us and we'll go out and inspect, which is on their time frame.
So if the buyer has agreed to an 18-month schedule, assuming 4 months for building permits and 14 months for completion, but no penalties for any delays, how can we impose a $250 a day penalty if he does not complete the building in the 18 months?
I'm not sure that's a question I can answer.
Well, then one of these brilliant attorneys could. Well, in that, in your agreement that you worked up, how can we impose a $250 a day on an 18-month project if the applicant has agreed that by 14 months he's going to have the building up and going? Because what I see is that it's going to be a hindrance in financing. It's going to be a hindrance in making this deal really workable. I can see if it was our City Hall project and we had hired a contractor and they we gave them a lot amount of time to do it and they did not finish it within the time frame that we had worked out, then I can see a imposement of the $250 a day. But this is a different subject. He's buying the property from us at a value which is substantially over, when you add up all of what he's paying, over the appraised value. Why would we want to impose a $250 a day penalty to make sure that the contract that you have already worked up has already said that if it's not completed by that time, then the property, then the contract can be voided, right?
Councilman Williams?
Yes.
If I could, I can turn this over to my partner, Lily Rango, who can address this question for you.
Good evening, Mayor, Council. That provision before you, it's Section 16 in the agreement. The intent was to establish a timeline to make sure that permits were pulled timely and construction was completed. The buyer did indicate that he could live with a 14-month period of time, and that was a comfortable time frame. And the objective was to create a remedy for the city in the event that...
I'm sorry, I can't hear you. I'm sorry.
I'm sorry. The objective was to create a remedy to the city in the event that construction lapsed, permits weren't pulled timely, construction wasn't completed, but not for unavoidable items that were not within the buyer's control. And there is some language there regarding unavoidable delays, and that was not the intent, to punish the buyer for unavoidable incidents. But the objective was to create a timeline that they could live with and some remedy to the city in the event that things weren't done timely.
Yeah, but my only issue is that if it's his projected timeline that he has offered to us as a guideline, then in the contract in which is wrote up, how I read it is that if it is not done by that time, then the deal is over from the city's point of view. That's the language in the contract.
Well, at that point of construction, the property would have already closed, and it would be owned by the buyer. This would be post-closing.
So why would we put that in the contract then? That if the project is not complete by that certain time, that the contract is canceled?
Again, the objective was to ensure that permits were pulled timely and the property was completed within a certain time.
But you see how confusing this could be, right? You say we're going to do it $250 a day. They don't complete it within 18 months, then the contract is canceled.
No, the contract is not canceled. The
Well, let
penalty,
me-
the penalty would be applicable. At
Okay.
that point, the closing would have occurred.
All right.
Councilman Williams, so the property remains with the buyer. It's simply a fee for the delay in not pulling permits and not completing the construction. But the property stays with the buyer.
But if he has given us a timeline himself that we have agreed to the 18 months, 4 months in preparation of pulling permits and all of that, then it's really the timeline that he's given us, so that he's saying that he can complete this project by that time, right? And then so he's buying the property at almost full price, above the value when you add up everything. Then why would we put this hardship on him?
That is why we're before you. It is the will of this council. If you wish to proceed in that fashion, the language is in there for the protection of the city in the event of delays.
And have we in the past done anything like this, a property we have sold before? And I mean, a complete buyout. I'm not talking about over time, 10 years, I'll give you such amount of money. I'm talking about a complete, here's the check, finance deal, a complete buyout of the property. Have we had this piece before?
Yes, Councilmember Williams, I'm Gail Sirota. I had worked on this before I left town for 2 weeks.
Yeah, I understand.
But I did numerous transactions, sales in the Park of Commerce, which were subject to agreements to build that were recorded, where the property owner had to complete construction of a certain amount of square footage within a certain period of years, because the objective on those transactions, as in this one, was to create development and to get, economic development. You need to have businesses built. And so that's really the motivation behind this from the city's perspective, is to make sure that this gets built within some reasonable amount of time.
Yeah. And I don't disagree with you. I think that if the buyer has said that this is the time frame that he needs, I don't think imposing such a heavy hand with this transaction is really necessary, because number one, Hyundai has site control over that, over the facility once the buyer has it. So a lot of the things that are more strenuous with Hyundai, because he has to produce by their timeline, which is a little bit way more stringent than what we have in this contract. And so what I'm saying is I would like to make this process a little seamless, that we're not so heavy-handed. We're working with the applicant who's investing in our community to provide more than 50 to plus 70 jobs within the area. And that's all I'm trying to get at. I think there's a little bit heavy-handed within the provisions of the contract. Any comment, rebuttal from what I said?
Well, it's really up to the council.
Okay, I just want to lay out my case for my colleagues, because I don't want to, because I heard the comment from Councilwoman Faircloth and Mr. Burgess that we want to make the city whole. And I think with his purchase price, with all of the other items that he's doing, is going to be over and beyond of what the market value is at a site that has a building on it. So I would wait to hear back from my colleagues, but that is my testimony and what I'd like to see taken out of the contract, and so that this process can go forward with its economic stimulus that it's going to do for our city. Thank you, Mayor.
Thank you, Mr. Williams. Any other questions from council? Mr. Burgess? Mr. Burgess? Mr. Burgess.
Thank you, Mayor. Just a couple observations. I saw in my package here that, you know, one of his things about not coming to the exact number was he had to pay the commission. He's the one that, in his own words, I believe, made a bad business decision there. So you can't hold the city responsible and make that part of the deal. That was a decision that was brought upon by the buyer prior to coming to council and asking for any kind of a deal, negotiation, or meeting or anything. So I don't really go with that explanation that he's got to pay that, because that was something that he set up and thought that that was going to get him down the road where he needed to be. So he needs to be fully responsible for that. I don't want to, and that needs to be taken off the table in my eyes, because the city has nothing to do with a business deal that he set up before he ever came to any of us. So if he's paying somebody a commission that's no longer involved or didn't do the things that was promised to him, that's an issue that he needs to take care of and not make the citizens of Homestead even aware of or responsible for. The dock stamps, and I would refer to our attorneys, any of them, are usually, unless it's included in the contract, are usually the responsibility of the buyer. Is that correct? Or how does that work? Because that's the way that I understood it. And
It can go, it's
it
really
can go either way,
subject
but
to
usually it's the
negotiation.
buyer.
No,
No?
I don't think that's the case.
Okay. Well, that's what I had been told when I asked.
Since the city doesn't normally pay taxes, and
Right.
dock stamps are a tax, and the transactions I've done, for the city, it's generally been put on the buyer.
Okay. Mr. Williams, and could I just, because I was talking with our finance director, when you got to the number of $2.4 million, can you go, if it's easily and readily accessible there, can you go back to that your math equation where you got to that number for me? I'm sorry.
If allowed, Mayor.
Mr. Williams, go right ahead, please.
All right, the original offers were 2.1, right?
Right.
And then the buyer, and matter of fact, Jay, would you please come to because I don't want to misspeak. If you don't mind, Mayor. And
yes, sir. Go
fellow
ahead.
council members. The original offer back, and this process has been going on since July, okay? So the original offer was 2.1 million for the property. Then it increased the offer to 2.2, and then it increased to 2.27.
Right.
Right? We got that. The appraised value is 2.325.
Right.
And the appraisal assumes the normal, consideration unaffected by the sales of concession, meaning that each party has paid their normal costs associated with the transaction. So in paying, and this is how I think the number came up, in paying the real estate commission, as you said, it was a bad deal, and documented stamps, the offer is compared up to 2.422 million. So this is like 97,000 over the appraised value of 2.3. And so that's where the breakdown. Now, what is the, Matt, can I get clarification? What is the commission on this piece? What's the commission? Yes.
I'm sorry.
What's the commission?
Good evening. It comes out approximately 120,000 and change for the commission.
All right. And what's the doc stamp for this? Any attorneys know? What would be the doc stamp? What?
My number, I mean, we still don't know exactly what it is, because we, as a buyer, we really didn't participate in paying the dock stamp, but it's about $15,000 to $17,000, I guess. It depends how the calculation is done.
15 to 17.
With the city.
Yeah. So I guess in arriving at that number, according to Mr. Burgess' question, as relates to not including the commission that is paid, can I ask a question to Councilwoman Waldman as a real estate agent? How is usually a transaction like this handled as a buyer or seller?
Okay.
Hang on 1 minute.
I'm just trying to get clarification.
But that commission that he's paying, Mr. Williams, and correct me if I'm wrong, is not a true commit. He brought that guy in, quote unquote, as a lobbyist. The guy registered as a lobbyist.
Right.
So the deal that they had set is not your normal everyday real estate commission.
Okay.
So I don't think it's fair to ask how that is done, because this gentleman was brought in, registered as a lobbyist, and now he's getting paid even though he didn't fulfill his stuff. And in my eyes, if he's got the money to pay this gentleman $120,000 for a failed job, he's got $45,000 in the bank to bring that number up to where it needs to be for me.
Okay.
And I'll leave it at that. That's the end of my questions.
Thank you.
Mr. Williams, you want
Yes.
the floor again?
May I ask
Yes,
Ms.
sir.
Wallman a question now? Ms. Wallman, how is a deal you've structured like this?
Usually, if there is a property for sale and there is a real estate agent involved, then the person who is buying it usually has a buyer's agent working on his behalf. In this case, I was worried about this in this case because the city didn't have a realtor involved. It was your option to bring in a buyer's agent. And I think you understand that. You brought in the real estate company. There was no need really to bring in a realtor. It could have been done through your attorney and through our attorneys. So I believe that the real estate commission is your choice because you brought the people in to represent you when there was no other realtor involved.
Right, okay.
And that's an
So-
honest answer.
Well, that's what I want. I think it's transparent. I think based on your history. So Jay, now you're hearing all of this dialogue because of that. How do you?
May I just say just a couple of words? Good evening, Mayor and Vice Mayor, all council members, and city manager, assistant city manager Kate, where I know I drove you nuts last 3-4 conference calls. She's not here tonight. Okay. Anyhow,
she's here.
She's here. Okay. Thank you. There's a lot of phone calls there. A lot of people on the line. First of all, I do want to clarify about the real estate agent. My life has always been, I've been a businessman in one location for 34 years. And any property that I purchased, whether it was a personal real estate for my home or commercial real estate, that I'm always want to go to the best source to find a property. And this location was not the first choice. We looked at several property, and for me to go out there and look at several property in Homestead, it would have been almost impossible for me to figure out what is the right things for me. Now, by having a real estate agent coming in and making you an offer, it was really totally, I didn't know I was making a mistake from the go. It was just past experience. Now, what I got into the problem was that when the real estate agent did not do the proper way to serve this, or I don't know what word I need to put into it, because some of the council member had a problem with this real estate agent, how it was approached. There was a lot of disagreement how it should have been approached. And that's when I immediately stepped into this conversation or negotiation, I call it, personally myself. And since then, I've been on every meeting, and I've met most of you guys one-on-one to exactly tell you where I'm coming from. Just like I should have done at the beginning, I agree. But it was not really done in intention or knowing that I'm making a mistake. But to make it clear that the real estate agent has been terminated for my team. But I signed a contract with a real estate company that represents this particular deal. So I understand the commission part is a big money. So the way I understood it, as I'm buying property, whether it's a commercial or the personal, there's always a buyer side real estate commission involved, which is about 3%. The other seller side pays a 3%. That's what's in my mind. But at the end of the day, that's not my expertise. I just want to get this property, picked out fast as I can and just keep moving. So that's my comment.
Mr. Williams? Okay. You still have the floor.
Oh, I want to release the floor for my other colleagues if they have anything.
Okay. Mr. Maldonado?
Thank you, Mayor.
Mr. Burgess.
Just two items in regards to, hold on, I'm switching between two applications here. So the only, well, not issue, but I guess only thing that I like to talk about is one, the second, which is the HUD disclosure and identification. Let me go back to my notes. Just give me a second here. HUD disclosure, okay. So my goal, again, I don't want to hinder this project. I'd like to see this move forward. I believe that this language came to play or came into the discussion when we were talking about the sale of the bowling alley when it was below market price. And so that disclosure, when we had that conversation back then, again, and I asked you guys last time, are we still on the hook from that? Because from my understanding last time, we were no longer, we didn't have to pay that back.
The long and the short of it is we really don't know. There is basically an unknown liability here. And the big question is, well, nobody can answer that question definitively. The dilemma with this document and this transaction is either if the worst case scenario happens, where HUD says we want X dollars and we don't even know what the dollars would be, will the city pay those dollars or will this buyer pay those dollars? And that really is the crux of the issue, is who will assign the liability. And so the worst case scenario would be that the city sells this property, assuming the city assumes this liability, the city sells this property, 2.4, whatever the number is, we get the money, and then at some point HUD says, we want 2.5, 2.1, $5. I don't know what they're going to ask for. They may never ask for it, but if they ask for whatever that dollar amount is, theoretically, we could be responsible for paying that. And so that really becomes who ends up assuming this liability. And of course, our lawyers have advised, and I think rightly so, that we shouldn't bear that liability. And I'm assuming the buyer's lawyers have advised him that he shouldn't assume that liability, and therefore, that's the dilemma.
Is there any case law or any where that's happened, where HUD has, this kind of scenario has happened, and maybe lawyers in the real estate department?
Well,
has there been a case in the past where HUD has come back and asked for the money that we know of?
The way we understand it, because we had spent a lot of time on this when we were dealing this with the bowling alley.
Right.
What we believe, and the reason this provision has been in every document since we've been selling this bowling alley property, has been that for the most part, we believe the people that wanted to buy it for a bowling alley were willing to assume that liability because HUD gave us that money because they determined that the bowling alley use fit within the program requirements. And so the federal government says, we'll give you money if the money is going to be used for something that we see as part of the program that we're supporting. And so the risk was fairly minimal because we went from bowling alley to bowling alley. The biggest unknown here is because we're going from bowling alley, which was an approved use, to car dealership, which is an unknown use. That's the bigger piece of this puzzle, and what makes this one slightly more risky than the previous one because it's now no longer the use. What we were told at the time, both from the previous finance director and also the lawyers at the time that were going back and forth with HUD, is that yes, from time to time, HUD does ask for money back if they've given you money for something and then you turn out to sell the property. And the reason for that is the obvious, is they don't want to give you money for a specific use and then you flip the property and sell it to CVS when the purpose of the money was to create jobs for kids or for the underserved or whatever the case may be. And so that really is the issue here, is we are totally in the dark in terms of what could happen, and it's a function of who's going to assume that risk.
Have we asked about this use and how it falls under the HUD definition? Does it fall under the use, the definition of use of what they're asking for?
The lawyers, you guys didn't ask, right? Nobody, I don't think anybody's asked. Kate, nobody asked, right?
And I asked this, and I get it, you know, if we would have sold it under value and then HUD would ask for the money, then we would be out of pocket. We'd have to give it back. But in this case, if we have the money.
Well, no, the problem is, it depends on how you define being made whole. Is that there is right now, Carlos, it's a $2.5 million $2.5 million liability and anticipated income, correct?
That's correct. The amount of the sales price is the current liability.
Okay, so in other words, what your books right now say is that CRA owes a loan that needs to be paid back, and it needs to be paid back from the proceeds of the sale. Your general fund shows $2.5 million worth of anticipated revenue, and therefore, because the loan is going to be paid back. So theoretically, if the transaction is done, they give you, let's just say for ease of math, $2.5 million. That money will come in. It'll be used, it'll be given to the CRA for the CRA to pay us back, and now we have the $2.5 million. Then what happens is, if HUD says, oh, that's our $2.5 million, then you have to take that $2.5 million, give it to HUD, and now you're minus $2.5 million in your books. So that's really the problem here.
Could we, just a question, if that was the case, could not the city give back the money to the CRA to be used in the original intent?
Well, it really comes down to the philosophy of what that transaction was back then. Somebody determined that city money is going to be used to do that transaction, the shotgun property transaction. And then the idea was, okay, well, we don't want to have that loss, so when we sell the property, we're going to pay back that money. So this is just a function of, that was the original intent. If you don't mind not getting paid back, in essence, for that loan, if you have to give the money back, then that's the policy question. And you can very easily, with one stroke of a pen, shift this liability from them to you. It's just a policy question.
Right. Well, there might be a thought for this council to think about, because if the money, you know, at the end of the day, it needs to go back to the city somehow, whether we keep it or whether it goes to CRA.
Well, I'm not sure I understand whether you keep it or you give it to CRA.
If you require, I mean, to avoid, HUD would take it, let's say theoretically, HUD would take it from us. Let's say if they want it back because the city has it, because you made a profit on it. Wouldn't it be easier just to give it back to the CRA so they can use it for the original intent, to help out the
You wouldn't be giving it to the CRA. The CRA has a liability. They owe a debt of $2.5 million. So what would happen is that debt has to be paid. And so if, in fact, the city sells this property for $2.5 million and then HUD says they want it back, then in essence, either the CRA will continue to have that debt of $2.5 million and either be forced to pay it back through CRA funds or never pay it back, which would mean that the city would have a liability of $2.5 million.
Okay, question. Okay, that was it. That was really my only question. My only concern, again, I thought this language in regards to that was just brought up for the bowling alley, when it was a bowling alley deal. Now that it's, you know, a car dealership, I figured it'd be different, so, okay. Thank you.
Ms. Fairclough?
Yes, thank you, Mayor. I have a question. And looking at this, I think you proffered a very respectable offer, and I really didn't want us to walk away from $2.27 million because of $49,482. But then my question is, how can you be responsible for paying a $120,000 commission fee to someone who didn't do the job? Was there specific deliverables in your contract that you signed? Because I don't see what was delivered for you to have to absorb the cost of $120,000 for a commission and not pay the close to $50,000 to completely make the city whole. So I'm having a hard time with that.
Yes, there was a contract, agreement signed between myself and the real estate company that within a certain amount of time, I believe it was 180 days, property was purchased within that area that I was looking for, and I'm responsible for their commission.
So as a result of that, you have to eat that cost. So you would like the city to eat the cost of $49,000, close to $50,000, because you have to pay this commission fee?
No, that's not the reason for the $49,000 difference. As far as my agreement with the real estate agent for 6 months, it was strictly based on, I thought in my mind, anytime I buy a piece of property, the seller pays 3%, there's a seller agent, then you have a buyer agent. So seller normally pays to their agent 3%, and the seller will pay the buyer a 3%. It's not as a standard 6% commission. But that $49,000 really is not because I determined that commission. It was strictly based on additional expense I'm going to be incurring. And in my first offer of $2.1 million, the $2.1 million was including a lot of the permits and fees that I got to incur. And when we do a negotiation with the city office, several conference calls, they told me that, look, we're not going to even talk about all those fees. So I took all that off the table. And then calculation of a demolition of the property, I'm getting an estimate anywhere from $50,000 to about $80,000. So really, it was not $49,000. It wasn't because I want you to pay the part of the commission. It was more of my budget and expense that is going to go with that property, because I can't utilize that building system right now. I have to demo the building, and I have to rebuild from the ground up. And that was probably it was the main reason. It was really part of the negotiation also. Because at $2.1 million, it was including all the permit fees and all that, and city folks clearly told me, said, look, we can't do that. If we have to do it for you, we have to do it for everybody else that comes in trying to buy a piece of property from us. So I took everything off the table at that time.
I know the last time you were here, I said it very pointedly to you that you needed to be a bit more flexible. And I see that you were beginning to bend with 2.1, then 2.2, now 2.27. So I commend you for being flexible as I had asked you to be. But with $49,482 break the bank for you, would you like for that to sink the ship and this deal not go through? Some of the other items, I see that we can kind of work our way around that, because I think our attorneys did a very good job of putting some sharp teeth into this contract, which I think we need to be a bit more flexible on our end. But would you like for that to sink the ship tonight?
Yeah. I feel a little bit, I don't know how I answer that question, because I don't know if I never negotiate this kind of numbers in front of the camera, all these people. I don't know if anybody ever done that before. But I've done a lot of negotiations in my lifetime, well over millions. To answer your question is absolutely, I will consider anything that is going to make this deal possible as far as a number-wise. Now, as a reminder, Councilwoman, that my first offer was $2.1 million with all the permits that it was going to go with that property. So that fee alone would have been a few, I will imagine at least 100,000, maybe 70,000. But I would imagine about 80 to 70,000. But to answer your question, would the $49,000 going to break the bank? Absolutely not. It won't break the bank, because I can make that up in the next 10, 15, 20 years.
Come on, make that.
Right? So my question will be, though, if if I can bring that number down low enough to get where we need to get to, or satisfy the city, I guess, can we get rest of the condition so I can move on, so I can go to bank, I can go to manufacturer, guys, we got this deal, let's move on, because my biggest fear right now is, one, is the construction cost and the interest rate. Because the longer that I wait, it goes up every single day. And I've been saying it in the email, I've been saying it on the phone call, until we open that door, start selling, there's not a penny anybody's going to make out of it.
Through the mayor, if I may, what I see, and I'm just going to filter this through my perspective, is right now we're bleeding money on that property, and it's time for us to turn the page in that chapter in our history. And when I look at this project, I see that it's coming back, could potentially come back on the tax rolls and create jobs in our community. And who wants to walk away from jobs and providing our residents the opportunity to work? And I always try to reach that happy medium and build a consensus. And I'm a little disappointed that you have to shell out $120,000 for someone who really wasn't effective or impactful, in my opinion. But I do also want to make sure that our taxpayers aren't really left holding the bag with $49,482. So for me, and I'll be quite honest, I'll be willing to work on the other areas if you are willing to come up to 2.319482. That's the $49,482 if my math is correct. Whatever those numbers are.
I mean, you know, again, everything is negotiable when it comes to numbers, but if all city council members is okay with that and we can wrap this deal up, I'm willing to give an answer yes. I don't know what to say. I mean, I can make up the $49,000 and as soon as I open the door, start selling car for about a year. But at the end of the day, it's going to take me about 7 to 10 years to pay back what I put into that store. So, what's under the 49,000, right?
That's where I am with that.
Anything else? That's it. Vice Mayor, Ms. Wallman, then Mr. Williams.
Perfect. Thank you, Mayor. I think I made my position clear over some of the last, we've dealt with this a bunch of times, and so I think I've made my position clear as far as how I feel about the overall project. You know, my only comment tonight is, so I don't want to kind of waste or continue to hash this out. My only concern is I think most of these issues are really policy-based. You know, the price that you want paid, does it make the city whole, does it not make the city whole? You know, restrictions, building, construction time, I think those are all policy decisions, you know, to be hashed out. My real concern here, however this plays out, is really the HUD issue, because to me, that's the biggest holdup in my mind. I think that's where we have the potential to have this come back and haunt us in the future if we don't address this now. And I read your email that you sent to us, and your position is that this really isn't an issue. It's not relevant, that there is no liability for the city. So in that case, you know, I think that you know, you should then take that liability on in case, if you don't think it's there, if your attorneys have rendered an opinion that there is no liability to be worried about, then it's really a non-issue for you. It should be a non-issue for you, and therefore it should be no problem having you take on that liability if it means you get to close this deal. Because my concern is one of the selling points that you're making, or that is being made in favor of going forward with this deal, is the fact that we, the city, will now have 2.2, 2.3, you know, depending on what the number actually ends up being, dollars that we can now work for. You know, we have a lot of we have a lot of revitalization efforts that we're doing. We have a lot of projects that we're working on, and so it would be nice to have those monies to possibly apply toward these projects or future projects, even additional projects, to continue to make this city better. But my concern is that with this HUD lingering out there, and our attorney's not willing to say whether or not we do or we don't have liability, if we ultimately do have liability, then those monies that now we're counting on, that's kind of making this deal somewhat, you know, attractive, all of a sudden hits us in the backside, and now we're struggling to find monies that we've already committed to spend. And so that's my biggest concern. So for me, and the only point I really want to make tonight is I think that HUD issue is the biggest issue, substantive issue, that needs to be, we need to be concerned about as a council from a future standpoint, and making sure that we don't set ourselves up to be haunted by this deal in the future. The rest to me is all policy. It's you know, whether the majority likes it or dislikes it, I mean, I think it's going to go through one way or another, you know, with the majority rule, but that's the only thing I think we really need to address as a council. So that's That's my comments. Thank you.
Thank you, Vice Mayor. Ms. Waldman?
Yes, thank you, Mayor. I haven't seen your buyer's broker contract, the one that you said you signed with your realtors,
A contract or agreement for the 6-month agreement?
whatever you signed. I haven't seen that. But I will tell you something. I learned this a long time ago when I first started real estate. You can negotiate with your realtors. Now, a little piece of the pie is better than no pie at all, because if this deal doesn't go through, they don't get anything. Do you understand what I'm saying?
Yes, ma'am.
And I'm surprised that you and your attorney haven't done that, because in my opinion, your realtors have done absolutely nothing for you but hurt you. So
Believe me, I feel the pain. I've been in
I
just
feel your
about every
pain.
meeting.
I feel your pain myself, but
And I thank you, though. I'm taking
but I'm
it.
telling you,
Yeah.
you can negotiate, and if you really have a real estate attorney look at that agreement, it might not even be valid. But with that being said, if you pay them that full price, then shame on you, because you shouldn't have to do that, because they haven't done anything to help you. If more than anything, they've hurt you. So that's my first issue, that I hope you go back and you negotiate with them. My second issue is that with the HUD predicament, you know, I can understand when we were selling the property for $500,000, $600,000, $700,000, that of course that responsibility should be on the shoulders of the people buying that. My question has been to myself, this isn't going to go away. This is something that we as a city are going to have to deal with sooner or later. We're going to have to deal with it sooner or later. Maybe it'll never come to fruition, maybe it will. You feel strongly that it probably won't. Our city doesn't know, because that's what government does. We don't know. We don't know what's going to happen. And we just have to sit out there and say, we don't know, because that's the honest to God's truth. But just as an alternative, because I don't have a feel as to how my council colleagues are leaning one way or the other. But if worse come to worse, you know, I'm in the business of negotiating. So, you know, split the difference. If HUD should come back, if they should come back, then let's split the difference and put it in the contract. And the reason I say that is that I personally don't think they will either, because I think we're doing, you know, we've sat here with this property for God knows how many years, and you know, we all wanted family entertainment there, but it just didn't happen. And nobody tried harder than this council to bring a bowling alley back to Homestead. So now we have you, and you are a viable business person. I've checked you out. I mean, I know that what you're telling us is truthful, and you're above board, and I don't want to lose you. I'm just going to put it out there. I don't want to lose you. But we have to come to some agreements, and I think the fact that I don't know if you have a counsel here tonight. Do you have an attorney here tonight?
Yes, ma'am.
But you know, I'm sure that they'll probably tell you the same thing, that there's probably some negotiating that can be done between you and your realtor. Let me tell you, if I was your buyer's broker, I'd be happy to take whatever you were willing to give me. Because, like I said in the beginning, piece of the pie better than no pie at all. And there's no reason why you should be put in that predicament. But that's your problem, because you did that. And we understand.
No, yeah, I clearly understand it, and you know, again, I did put them on a notice, so you know that if there's any increase in what my last offer, which was my final offer, then something's got to give from the real estate agent. So the seed's already planted in their mind.
And they better listen.
Okay. And as far as a HUD, one of the main reasons I didn't get my a HUD special attorney, I'm sure they're out there, this deal would have taken another months before we get to this point. And my clock has been way against me 4 months ago. Thanks to the city manager, he had us send a letter, request to the manufacturer that we're in the middle of negotiation. So they gave me until end of this month. At very best, I can probably push to the beginning of a couple more days.
Jay, if I could just say one more thing with the permission of the mayor. For many years, I held a lender's license. A lot of people don't know that. I mean, and it's hard to get a lender's license, and I held that lender's license. And I understand mortgages. I understand exactly what you're going through. And I can tell you that nobody that's going to stand before us that's going to go out for financing will be able to get a loan with that blanket hanging over them.
Thank you.
That is the honest to God's truth. Now, you might disagree with me, but I'm telling you, as a prior lender, owning my own company, working all over the United States of America, I can tell you that no one will get a loan with that covenant hanging over you.
And that was my second reason. Besides the times the clock's against me, I spoke to, I got to be upfront with you.
And let me finish.
Yeah, I'm sorry.
Because I'm on your side here. Let me finish. So when we had the lower offers of $500,000, $600,000, $700,000, I didn't feel sorry for them because they were coming in probably paying cash for that. And then how they did their rebuild was their issue. But for you, with financing and with your situation with the Hyundai company, and I don't understand all that, but with that, they're not going to allow you to do it either with a covenant on you. So that's how I stand, and I just wanted to let my colleagues know. Thank you.
Mr. Williams?
Thank you. And I invite my colleagues to go back into their packet and look at the last letter, December 22nd, 2011, to Lillian. Is this you? This, okay. Now, yeah. It says, and these are questions in response to what we have, I guess, it's the fourth letter. I created my own little booklet, so I don't know where that is in the packet per se. But if you turn to, after Exhibit A, after the page 39, y'all, it's the letter is dated December 22nd, 2011. Okay. The last clause in that paragraph, the second to the last paragraph, the City of Homestead received a direct CDBG-DR grant from HUD. Formally closed out that grant in 1999/2000. The city was not an entitlement community at the time of the award. So we consider Homestead the other recipient, referenced in 570.0505 dot. As such, the national objective requirement at 570.208 and change of use provision at 570.505 were applicable for the period of the grant closeout 1999 to 2000, and for 5 years thereafter through 2004 to 2005. After the 2004 and 2005, the property was no longer subject to any CDBG requirements, period. They go on to say, we hope this provides the answers you and the city were seeking, and please feel free to contact this particular representative. Then I said, let me call my attorney, right? That's the good thing to do. I said, give me an interpretation from your perspective, in your legal opinion and legal mind. Matthew Pearl, partner at Wise Sorota Huffman Cole, said number 4, in December of 2011, The office of the city attorney received a letter from Jacksonville field office of HUD stating that neither the bowling alley nor the proceeds derived from its sales was subject to the regulations. So if that is the case, and this is the last letter we got from HUD, how can we tell this gentleman that we're going to impose this restriction on him when the letter has really clearly intent says that the grant has closed out, has had its use? We're in year 15, 2015 from that time. So how can we impose on this gentleman that burden? Okay, so that's my comment. And then to you, Ms. Jane, and to my colleague, don't let $49,000 kill this deal since you've been working on since July of 2014. As a friendly suggestion. Okay. So that's my rationale. I did my research. I went to HUD. And I looked at their interpretation on those statutes, and so in my due diligence, I've gone beyond what I should have gone in relying on the attorneys to make sure that I really understood the concept and grasped the understanding of such contract. And so with that, Mayor, I would ask that be taken out, that be restricted, that piece be taken out, and that I will make the suggestion that we make the city whole at what did you say? 2.319, what did you say? 482. And those covenant restrictions as relates to the $250 penalty, I ask that be taken out. And that's where I am with this. Thank you, Mayor.
Okay, Mr. Burgess?
Thank you, Mayor. I guess to any one of the attorneys, what Mr. Williams so eloquently just said, if HUD shows up down here in 2017, and we go to them with that letter from 2011 and recite what he recited to us tonight, what's our legal recourse, I guess, to them to tell them, look, we've gotten this, we followed this letter in good faith, and we're not going to pay you, or we don't feel we're responsible to pay you back on that because of this letter and that, and we followed it in good faith. 4 years we sat around and waited until we acted upon it, and now nothing was ever transpired in between those 4 years. Now you're showing up 2 years, 3 years later, 6 months later, whatever it is. What does that letter mean?
Mr. White.
I can add some light onto that. The rest of the opinion that we gave to Councilman Williams regarding this issue, we go on to say that the city's received contradictory guidance from HUD. So the previous letter was the opposite, that the city was still responsible.
When was that letter received? Because I don't recall it off the top of my head. So how many years in between contradicted?
That was May of 2011.
Okay.
Yes. And we go on to say that it's really impossible to determine whether or not the bowling alley and the proceeds received from the sale would be subject to the regulations because of the contradictory interpretations that we received from HUD. And if you all were to proceed with a contract, there's an inherent risk involved in not being indemnified by the buyer. So we can certainly make that argument on behalf of the city, but whether or not it would stand with HUD, I don't know.
Thank you. Thank you, Mayor.
Mr. Maldonado?
I'll yield for now. I'll request it in a minute.
Vice Mayor?
Just a quick question. I mean, is there any reason why we haven't tried to put this to bed? Because as Councilwoman Waldman said, I mean, this is something that's hung over this property and will continue to hang over this property. Is there any reason why we haven't try to get clarification on the conflict between the two letters? Is there a risk in there that maybe they call the monies back automatically? I mean, why have we not gotten a clear answer so that we know what we're dealing with? Or is it possible to get a clear answer, you know, as far as sending another letter and get them to clarify which one of those is their position?
Up until this was an issue for a car dealership, the people who wanted to take the property as a bowling alley had agreed to this language to assume the liability, and therefore, since that was the case and we didn't have any liability and the use was the same, bowling alley to bowling alley, which we know HUD had determined was the national program and guidelines, it didn't seem to make any sense to go beyond what we already had. In this particular case, he hasn't really had time because you're not going to get another letter from HUD in 5 minutes. So we could try to get one, but I doubt we're going to be able to meet his deadline.
Okay, that's probably like this is my biggest concern on this deal. And again, I'm not supportive of it, so no one's really going to care per se what my position is because I think I'm the minority here. But I'm concerned about the city's liability on this, and so to me, I think it'd be key to get a clear delineation. Regardless of what happens with this particular item, if it goes through, then I think it's a dead issue. But if it doesn't, for any reason, I think we need to get clarity on this so that going forward, this isn't where we keep rehashing the same issue over and over again with the unknown risk.
And we just didn't want anybody to not be clear that at some point in time, if this transaction goes through with us assuming the liability, that the city could be forced to pay back potentially $2.5 million. And so that's a policy question for you all to decide whether that's a reasonable risk or not. But we didn't want anybody to think afterwards that there was not a clear, the information wasn't clear, which is, this is a very clear decision about who is going to bear that liability.
All right. And what do you guys think time frame wise to get a response back from HUD? I mean, if you guys ask tomorrow, where do you think, how long do you think it would take to get a response for them or clarity between these two letters so that my colleagues' consciences are clear when they move forward one way or another?
Well, I can't answer that question. Carlos, do you have any idea how quickly we could get an answer from HUD?
No, sir, I don't know.
Thank you.
Mr. Williams?
I guess what I'm making reference to is that if that is the case, then we subject to all 4 letters we have received. Then from way back when Kurt Ivey was city manager, 2004, are we subject to that? Of that? So when I hear the word ambiguous language, I don't really look at the letters 1, 2, 3, and 4. I look at the last interpretation of what they have sent the city. Because in that case, everything I've said could be subject to come back. And I don't see where in our argument that we're making that it's very clear. To me, I don't see where it is any discrepancy or any ambiguous language in the last paragraph, because in the first page, it's us asking them questions, and then the last page is them really answering our questions that we've asked. And from that, as I have read continuously, the property is no longer subject to any CDBG requirements. The time has got me. So the action of this is that when I hear the attorney say that they're giving contradicting guidance, you were saying on all 4 letters or on the last letter?
With the Councilman Williams, with the last letter and then the preceding letter in 2011.
What is the contradiction on the last letter?
The May 2011 letter.
No, December. What's the contradictory language?
The last letter that you received in 2011 stipulates that there's no liability. The previous letter, letter number 3, states that there is liability.
So we sent the letter, they said liability, then in the last letter that we sent, they said no liability. How's that contradicting it if they have already determined? That's not contradicting to me. The last letter is what we go off of, to what I'm going off of, to say there is no liability. And we're making it a liability, but I keep saying it's a liability because so let's go back to letter number 2 and 1. What are those interpretations? What's the contradictory language in 2 and letter 1 and 2? What's the contradiction in 1 and 2?
The 2004 letter is the first letter that you received, and that letter discusses or points out that that letter was from the Department of Community Affairs, stating that the proceeds that were generated from the sale of the bowling alley would no longer be subject to HUD oversight or grant program requirements other than HUD's desire that it be used on activities deemed by HUD as an eligible use of grant funds. So that was a letter by the Department of Community Affairs, who helps administer the HUD program, but not from HUD. The second letter in 2008 was a letter that was addressed to our office, again received from DCA, stating that the regulations governing the disposition of the property, known as the program income provisions, did not apply to the bowling alley, and as such, the use proceeds generated from the sale were not subject to any oversight, review, or monitoring.
All right.
And then,
so we're two. How many are we? We're 2 for. Are we 2 for? Are we 3 for 1 or 2 for 2? In the contradictory, letter 1 states that we have what? Or we have liability in letter 1?
Yes or no?
well, that's a letter from DCA, and so I think you would, it appears or it references that there would not be liability. Same with letter number 2.
Letter number 2. Then letter number 3 is the contradiction of it may. Now letter number 4 says is not subject. So we're 3. Right. We're 3 to 1. What other determination do we need to be clear if we're 3 for 1?
Mayor, if I could answer that.
Let me know. Wait, George, because this is. I still have the floor.
Okay.
According to Mayor, can I still make my
Yes,
point?
sir. Go right ahead. You
Thank
have
you.
the floor.
So if we are 3 to 1 in these letters, and the last letter says that we have no liability issues, according not only from the letter but from the interpretation of one of your partners at your law firm, that says in that the bowling alley is not, nor proceeds, from the sale are subject to the regulations. So why are we making this an issue when it's not really an issue?
Okay, first of all, I need a motion to extend the meeting.
Motion.
Is there a second? All in favor?
Aye.
Mayor, I can answer that question.
Mr. Manager.
Mayor, the position that the lawyers and the staff are taking here is not that what we have here is clear or unclear from the federal agencies. What we're saying is the document before you to sell this property is a policy decision on whether the city will assume liability in the event that the federal government says that you have to pay back them money. And so we don't know what's clear and what's unclear. All we know is that either the city will assume the risk or the buyer will assume the risk. And we feel the best evidence that there is some risk here is that the buyer won't assume the risk themselves. And so if there was zero risk here, the buyer, like the other buyers, would assume it. And I think that's really the answer to the question. And we agree with you, Councilman, that these letters are all over the place, and we're sorry about that. But for a finance director who doesn't work here anymore, who asked for something that nobody asked her to ask for, we would have 3 letters that all say the same thing, not 3 and 1. But unfortunately, her position at the time, and she truly believed that the city had liability based on her experience administering HUD programs. And that's the reason why she spoke to her contact with HUD, because she felt that there was some liability. And that's pretty much what we have at this point.
Mr. Maldonado? You guys mind if I open up the public hearing just to see if there's anybody in the audience who would like to come up?
I don't mind, go ahead.
Okay, I'm going to open up the public hearing. If you're interested in speaking for or against this, you're welcome to come to the microphone at this time. Mr. Maldonado?
Thank you. Question, the loan amount that we're talking about, the original loan amount that we got, not that the city gave, how much was it for the CRA?
The loan between the city and the CRA was approximately 1.7 million.
And explain again, how do we get to this number from 1.7
It
million?
accrues interest at 5.5 according to both resolutions, the one approved by the CRA board and the one approved by the city.
Okay.
Anything else? Ms. Wallman?
Yes, Mayor, pretty much everything's been said. I mean, you know, you wait your turn to
Right.
get to speak, and pretty much everything's been said. I think we have a strong case that we don't have a problem, but as I said before, you never know. But I go back to the same issue as before. The reason I really truly believe in my heart that it wasn't brought up before is because the price was so very low, and it was just, you're trying to compare apples to apples, and we can't, because this is a different situation. Again, you know, you know how I feel about the real estate commission. I told you that you should renegotiate that. That, in my opinion, you know, that's baloney. You shouldn't have to pay that. But as far as this goes, I mean, I'm ready to move forward. And I didn't know whether Mr. Williams was making a motion before.
Yeah, I did.
You did make a motion. Did you get a second on the motion?
No, not yet.
Mayor, did he?
Mr. Williams, if I scribble it down correctly, the HUD question would come out of the contract. The city would assume that. The price would be 2.31948, which is what I heard. And then the other question that I don't know that you included in that motion was the time of ownership and the penalty was.
Yes, the penalty of the $250 a day, because, yes, completion in your contract, exhibit number 2, item number 16.
Yeah, if I still have the floor, I don't know.
Yeah, that was, James, did you get that as far as what Mr. Williams' motion was?
What I have is that the HUD indemnification provision would be stricken. The sale price would be the sale price that's identified by staff, $2,319,482, and the completion of construction provisions related to the $250 fee that would start accruing if not completed by specified time frame would be stricken from the contract.
Is that it, Mr. Williams?
I would recommend.
That's your motion, clear. Okay.
I would like to make an amendment to that motion, Mayor, and to, what happened? Oh, he's gone. I looked up and he was gone. We've already ran him off. I'm sorry.
I'm sorry. And Councilman Williams, I think you also mentioned the, to remove the restriction on the transfer of the property.
By that you mean the 7 years that you were asking
Correct.
for it to remain? I would vote that I would recommend that we remove that, and I'll tell you why I say that. If someone was getting the steal of a lifetime with the $500,000, $600,000, $700,000 price, then yes, you know, we're making such sacrifices. But life is so short. Day to day, you don't know what's going to happen. Trust me. I know. I mean, I didn't know that I was going to have the kind of day I had today. My mother took a fall, and I had to take care of things, and life just changes every day. And if somebody's paying fair market value, to me, we shouldn't make them be tied in, especially to 7 years. So that's just my opinion. I haven't heard any discussion on that, but that's my opinion.
Okay, Mr. Williams has a motion on the floor. Is there a second on his motion?
Can,
Is there a second on his motion for discussion? Okay, second for discussion. Okay, Mr. Williams, you have the floor again? You asked for it again?
no, go ahead.
Let me just get this right, James. Read back to me what I have indicated to you. Please, I'm sorry.
No problem, Councilman. So the motion was to approve the contract with modifications to strike out provisions related to HUD responsibility and indemnification to the city by the buyer.
So as page 8, 13.2 and 13.3.
That would be paragraph 13 of the contract.
Yes.
The second item that you raised was that the sale price
Yes.
would be the sale price indicated
By staff.
by staff, $2,319,42. The third item was that the prohibition against transfer,
Item number 16 on page 10.
paragraph 14 of the contract, would,
14?
well,
Yes, 14 as well, yes.
so that, the prohibition, that contract clause would be stricken. And last would be the paragraph 16 of the contract was the completion of construction and the removal of the $250 day penalty that would be imposed if the buyer did not complete construction within the specified time frame. So that penalty would be removed from the
Yes.
contract.
Thank you.
Mr. Burgess?
Thank you, sir. One quick question for Jay, and you may have told me this in our meetings or our discussions. Your contract with Hyundai as the dealer is not contingent upon this piece of property. You've got that secured, and you're a Hyundai licensed dealer when you find land. Is that how it goes, or how do they work that so that we know? I mean, because Hyundai is a name that's been thrown around time and time again here through the discussions, whether you wanted it out there or not.
Yeah.
And so I'm just, is that you're locked in with them, and that's who's definitely coming here, and that's what the citizens of Homestead should anticipate seeing there if this goes through tonight.
Councilman, I have what I call an LOI, letter of intent, from the manufacturer.
That's what I was looking for.
Manufacturer that you named, and I want to tell you that the letter was sent from the city manager to them, let them know that the discussion's happening now, negotiation.
Right.
And then I had to go ask for the extension from them.
I just wanted to get that on the record,
Yeah,
that you had that.
I did bring a copy of.
You spoke to me about it earlier.
Yeah, I have a copy of the letter.
Right.
That it's necessary that,
Okay, thank you.
for the
Thank you.
contract.
Mr. Maldonado, then Ms. Wallman.
Thank you, Mayor. Just for the record, as I was going through this, my only concern above all was just that, I would like to see this happen, and my concern was for any restrictions that were going to hinder the ability for the buyer to secure a loan. Listening to my colleague that's in the industry, I wish we would have, maybe I would ask that question to legal, but that was my concern. That was the only thing that really popped out, in this whole discussion, is that I don't want to hinder anything that's going to not make this happen. It looks like it's going to happen. These things are going to hinder it, so I would move for removing it. So just to an agreement and for the record. So to strike any of the provisions that are going to hinder this deal.
Ms. Wallman?
Yes, thank you, Mayor. Jay, just for the record, your letter of intent, is it contingent upon you finding a property within X amount of days or months in order for you to get that? Because the question that Mr. Burgess asked, you answered that yes, you've already tied them in and you have a letter of intent. But I understood there was a contingency.
Contingency getting this address,
A property.
This property.
A property within so many days.
Correct. It was, well, we started earlier, beginning of last year, so on, expired.
So the answer is yes, there
Answer
is
is
a
yes.
contingency that you acquire a property within so many days to fulfill your obligation and commitment to Hyundai.
Absolutely.
Okay, thank you.
Absolutely. And real quick, the paragraph, help me out here, 9, paragraph 9, is that?
What?
The paragraph 9 here, is that up the table? City staff and the financial institutions discuss restriction of use of financial aid where it must affect, property finance.
Mayor, if I still have the floor.
You do.
Jay, your answer is yes or no?
Yes, ma'am.
Okay, thank you.
Sorry.
Okay. I can't support the motion. I don't agree with what's being proposed, but just for your own record, I hope you're successful if the motion does pass. But we do have a motion by Mr. Williams, seconded by Ms. Waldman. At this time, I'm going to close the public hearing. No one has come forward to speak.
Mayor, if I might.
Yes, may I ask a question? Because
Yes,
this
Gail.
wasn't clearly addressed. There is another section of the agreement, paragraph 9, which is permitted use of the property, which requires the property to be used as a dealership for 7 years, and provides for a deed restriction to that effect. And it's not clear to me from the discussion whether that has been raised as, I believe that Mr. Rivchin has raised an objection to it in his email to all of you, but I'm not sure if that has been addressed.
Mr. Williams?
Mayor, and I think I did say that, but as I said, that Hyundai has a greater restriction on this piece in their covenant, that the city is selling the property to buy solely for use of Hyundai. And so Hyundai, from my understanding, has site control over it, and it cannot switch to a BMW or Nissan dealership because that's not permitted. So I think that the way this language is written, or any other new motor vehicle dealership, in order to generate jobs and economic development in the city, buyer agrees that the property must be used as a dealership for a period of 7 years. And my only thing is that Hyundai is a little bit more restrictive. It says 10 years after issuance of temporary or permanent certificate, or TCO or CO, for improvements to be constructed by buyer or for no other use. Buyer's obligation to use the property as a dealership for 7 years will be set forth as a deed restriction and covenant running with the land of special warranty to be delivered by the buyer at the closing. I guess then, my question, Mayor, if I might, to Jay, this provision in here, how does that, how are we as a city protected that this stays Hyundai?
And I just want to clarify that it is one is a bank issue because you put a restriction to get a loan. But the most important thing, whether it's a bank or not, the manufacturer will have a minimum 10, possibly even 20-year site control, they call it. So they cannot I can't just say, okay, I'm going to give it up and then walk away, take the Hyundai dealership. I just can't do that.
Okay.
That's the rules.
So paragraph 9 then is what? How does it compare to what you're saying?
In paragraph 9, I just wanted to clarify when the city attorney, I apologize, I forgot your name, but to mention when you will go on the line by line on this, I just want to make sure that's all cleared out. As a councilwoman, as mentioned, look, what's under the 49,000? I say, you know what, if everything that I sent to the...
But what I'm asking is this 9, because we're ready to vote.
Right.
So this number 9, how does it affect you?
It'll affect me tremendously.
It affect you through what? Your financing or what?
Financing and getting the Hyundai to approve that. The Hyundai is going to have to override that.
Okay, all right. So,
Manufacturer's not going to, they're not going to accept the contract that way. The guy they're locked in for 7 years instead of their own 15, 20, 30 years they want to put in.
all right, so then amend my motion then to include number 9 to be stricken out.
There's an amendment. You want to second the amendment? Okay. Vice Mayor?
No, I was just going to say, actually, I would like to remove 9 because I don't want to see us get into a situation. Hopefully, you're very successful. Hopefully, this dealership does very well for you. It ends up being an economic engine for the city. But I don't want to see us get into a situation where we're now debating this 4 years from now, 5 years from now, because it has to stay a car dealership. You know, I think this is something that I think at this point, you know, sell it, take all restrictions off, and let the free market run from this point forward. So I wholly support removing any restrictions to keep it a particular use.
Thank you.
Okay, so the motion is made. There's a second. No more discussion. I've closed the public hearing. Roll call, Madam Clerk.
Councilman Burgess? Come on, B.
Come back soon.
Cautiously, yes.
Councilman Maldonado?
Yes.
Councilman Williams?
Yes.
Councilwoman Fairclough?
Yes.
Councilwoman Wallman?
Yes.
Vice Mayor Shelley?
Wait, what, are we voting on the amendment or the actual motion? Because there was an amendment made by Councilman Williams. I seconded that amendment. So is this for the amendment or is this for the final vote?
This is for the amendment.
For the amendment.
For the
Okay.
amendment.
So yes for the amendment to remove or to add that, yeah.
My fault.
Mayor Porter?
No.
The motion carries.
And now you vote on the
original
motion as amended.
As amended. Roll call, Madam Clerk.
Councilman Maldonado?
Yes.
Councilman Williams?
Yes.
Councilman Burgess?
Cautiously, yes.
Councilwoman Fairclough?
Yes.
Councilwoman Wallman?
Yes.
Vice Mayor Shelley?
No.
Mayor Porter?
No.
The motion carries.
Okay, tab, you needed tab.
I think there's another companion that goes with this.
Yes, there is. Tab 19, it's a companion piece. If we could take that up and then move on to
Okay, tab
20.
Tab 19, report from staff.
Yeah, resolution of the City Council of the City of Homestead,
Thank
Florida.
you.
Halting the accrual of interest on the loan by the City of Homestead Community Redevelopment Agency for the acquisition of those shotgun homes, providing for implementation and providing for an effective date.
Questions from council? This is a public hearing. I'll open up the public hearing.
I'll move it.
Close the public hearing. Moved by Mr. Burgess.
Second.
Second by Mr. Williams. Roll call, Madam Clerk.
Councilman Williams?
Yes.
Councilman Maldonado?
Yes.
Councilman Burgess?
Yes.
Councilwoman Fairclough?
Yes.
Councilwoman Wallman?
Yes.
Vice Mayor Shelley?
Yes.
Mayor Porter?
Yes.
The motion carries.
Tab 20, Mr. Williams.
Yes. I'm so sorry, man. Let me let me get settled here, because what tab is this? 20. Mayor, this is a discussion to St. Paul Missionary Baptist Church in my district on 4th Street, which is over 100 years old. In your report, there's an alleyway that's right behind the church that buffers the land that is not accessible as a complete alleyway. There's a manufacturer of fabric that is right next to, that blocks the alley. Then there's a house that blocks it. And so the church has been keeping up the upkeep of the alley that's blocked, that is not usable. And they're asking the council, and this may be because it's an alleyway, and maybe Julio could provide some insight on this one, to be conveyed to them so that because there's no access on either side. And if Pastor Stiles, is he here? If you don't mind coming to really paint the picture, and so we can get some direction to the city manager on how we need to do this, because it's really, they're really taking care of the property, and there's really no alleyway, the gates, the trees, so it's really non-existent, really. Mayor, do you mind?
Pastor, please.
Good afternoon, Council. Mayor, to all the councilmen. My address is 2545 Southeast 14th Street. I live here in Homestead. I pastor St. Paul Missionary Baptist Church. As Councilman Williams has addressed it, there is a alleyway or easeway, as you may call it, a service lane. It serves no purpose. The fabricating company that's on the north end of the city of that piece of property or that parable has closed off the north end of the lane, as well as all the way up to the property line which we own is closed off. The only thing that is blocking us between that is the property that we do intend on purchasing in the project that we have for the next couple of years. We have been maintaining that easeway for as long as the church has bought the property on the west end of the property.
And that's right behind?
Right
the church.
behind
Right.
the church. We own those 3-4 lots that is right behind the church. We would love to be able to fence off the area so we could allow our students to be with more accessible to the back end of the property to utilize for recreation purposes, but also not blocking it off so that no one could get in or the utility poles could not get in or whatever needs to be maintained. But we do want to have the right of way so that we could have our property to join up to each other from front to back. And as we get ready to proceed in purchasing the other properties, we would like to square it all off in the future. But as of right now, the lane is prohibiting us from allowing that to be done.
Ms. Wallman?
Yes, Mayor, thank you. There's quite a few properties throughout the city that the same thing is in existence. So I'd like to make a motion that we move forward, direct staff to do whatever necessary to give ownership to your church with those stipulations that the utility people will be able to come in and out, and because it really serves no purpose except to be there for you. So especially a church of your history. So that's my motion.
Is there a second?
Second.
Okay, Vice Mayor?
Yeah, I just have a question from staff, because I noticed there was no staff report or staff analysis on this particular item. I mean, is this an alleyway that is used still? I mean, is this what is the staff analysis on?
Yes, sir. We've looked into this. It's a public right-of-way, but there are utilities in it, correct? And the utilities we still need to access that. Evidently to the north, they vacated the public right-of-way and turned the right-of-way into a utility easement. We would recommend that we do the same thing to the south. So we'll be vacating the right-of-way, giving it back, giving it to the adjacent property owners, maintaining a utility easement in there. As long as the utility company can get access to it, then we're fine. I believe that the power lines under there serve about 50 customers, so we definitely need access to that area.
Okay, and so you'd still need to have, I guess, access with your truck, your bucket truck or something. I don't know exactly where the power lines on as it relates to this particular alleyway, but as long as that builds into your plans, so you'll have it, you'll be able to, I guess, use it in some way, but you'll still have to leave it as an alleyway to some extent. Is that what you guys are recommending?
We would just ask that there be a utility easement. The resolution that vacated the property to the north, that was a stipulation that the alleyway was vacated, but a utility easement was put in place. And with these electrical facilities are in the rear of the properties. And we have facilities all over town that are in the rear of homes and businesses. So yes, we like to be able to have access to it, if at all possible. But we do have facilities throughout the city that you can't get a truck to. The guys have to climb the poles. That's
Okay.
part of their job.
Yeah, I have no objection to it. I just want to make sure that from a staff's point of view, it doesn't pose a problem with you guys being able to provide service to any of those particular properties serviced by whatever utilities run back there. So if you guys say it's okay, I'm perfectly fine with it.
Vice Mayor, if I could,
the process that we would do is we would bring back before you a vacation of a right-of-way, which requires public notice and a finding that you all no longer need it for the public use, but we would reserve utility easement for the city in that process. So we can work with staff. We'll have to get a survey exactly of the length of the alleyway that we, if it makes sense to do the whole length, not just a portion of it. So we can work with the staff to do that and bring it back for you.
Okay, it's moved and seconded. All in favor?
Aye.
Okay, motion carries. So we are going back to the beginning.
And Mayor, since my time has expired, I might as well stay to the whole meeting.
I was going to say.
I can't get to Overtown by
We
8
are-
o'clock.
Yes,
Because
sir.
it's 9 o'clock now.
Mayor, so you've already handled the consent items, so
We're on public hearings, tab 6. I mean, item 6.
Together? I'll ask the mayor. Mayor, may I ask a question? I know I haven't pressed my little doodad here.
Go ahead.
But can we bind some of these
That's what we're gonna-
together? Because there's no reason why we shouldn't be able to do that.
So,
James, what can we put together?
Mayor, yes, we'll start the quasi-judicial section of the agenda. We can take tab 8 by itself, and then tab 9, tab 10, 11, and 12 all deal with bay winds and the various subdivisions in bay winds. So I can read the titles for each one of those. We can collectively have a public hearing on those, and then you'll just need to take a vote on each one separately.
Okay, so we're taking tab 8 by itself.
Yes, sir.
Okay, tab 8, please.
So please be advised, the following items on the agenda are quasi-judicial nature. If you wish to comment upon the items, please indicate the item number you would like to address when the announcement regarding the quasi-judicial item is made. An opportunity for persons to speak on each item will be made available after the applicant and staff have made their presentation on each item. Swearing in, all testimony, including public testimony and evidence, will be made under oath or affirmation. Additionally, each person who gives testimony may be subject to cross-examination. If you do not wish to either be cross-examined or sworn, your testimony will be given its due weight. The general public will not be permitted to cross-examine witnesses, but the public may request the council to ask questions of staff or witnesses on their behalf. The full agenda packet on each item is hereby entered into the record. Persons representing organizations must present evidence of their authority to speak for the organization, and further details of the quasi-judicial procedures may be obtained from the clerk. In accordance with Code Section 2-591, any lobbyist must register before addressing the council on any of the following items. At this time, council members must disclose any ex parte communications they've had concerning the following quasi-judicial items. Hearing none, at this time, the clerk will... Oh, I'm sorry.
I pressed the button
I'm
here.
sorry, it didn't work.
Moving too fast.
Yes, I had a conversation with the applicant for tab 9 through 12.
9 and 12.
Not for 8, though. 9 through 12.
What's 8 to 12?
Hearing no other, at this time, the clerk will swear in any persons who wish to testify on the following quasi-judicial items.
Please stand and raise your right hand and repeat after me. I, please state your name, hereby swear or affirm that the information I present shall be the truth and nothing but the truth, so help me God. Thank you. You may be seated.
Tab 8 is a resolution of the City of Homestead, Florida, granting site plan approval for a 9,400 square foot retail commercial building on an approximately 0.93 acre parcel located at the northwest corner of Southwest 312th Street, Campbell Drive, and Northeast 15th Avenue, as legally described in Exhibit A and providing for an effective date.
Staff report?
Yes, sir. Staff recommends that we approve the site plan. Based on this, you'll recall that this is resulting from a Fluidra action that we undertook last summer and had come to an agreement which was approved by the council about how the property would look. We've subsequently worked with the property owner and developer to develop the site plan. It is in conformance with that. It is in conformance with the code. So again, we're recommending approval.
Vice Mayor?
Just clarification. So essentially, we've already really seen the site plan. This is just now has Family Dollar written on the side of the building. I mean, everything else is pretty much in conformity with what we had as that settlement that we accepted, correct?
Yes, sir.
Okay, thank you.
Okay, this is a public hearing, so if you'd like to speak for or against this, you're welcome to come at this time. Seeing none, I'll close the public hearing. Any final questions, comments from council? Is there a motion?
Move it.
Is there a second?
Second.
Roll call, Madam Clerk.
Councilman Maldonado,
Yes.
Councilman Williams,
Yes.
Councilwoman Fairclough,
Yes.
Councilman Burgess,
Yes.
Councilwoman Wallman,
Yes.
Vice Mayor Shelley,
Yes.
Mayor Porter,
Yes.
the motion carries.
Tab 9, 10, 11, 12.
Yes, Mayor. Tab 9 is a resolution of the City of Homestead, Florida, granting final replat approval of a 269-unit single-family residential subdivision for Baywinds Plan Unit Development, combined residential pods D and E within the Baywinds Master Development Plan, located at the northwest corner of Southwest 328th Street and Southwest 142nd Avenue, as legally described in Exhibit A and providing for an effective date. Tab 10 is a resolution of the City of Homestead, Florida, granting final replat approval of a 140-unit single-family residential subdivision for Baywinds Plan Unit Development Residential Pod C within the Baywinds PUD Master Development Plan, located at the northwest corner of Southwest 328th Street and 142nd Avenue, as legally described in Exhibit A, providing for an effective date. Tab 11 is a resolution, City of Homestead, Florida, granting final replat approval of a 167-unit single-family residential subdivision for Baywinds Plan Unit Development Residential Pod G within Baywinds Master Plan, located at the northwest corner of Southwest 328th Street and 142nd Avenue, is legally described in Exhibit A and providing for an effective date. And finally, Tab 12 is a resolution of the City of Homestead, Florida, granting final replat approval of a 107-unit single-family residential subdivision for Baywinds Plan Unit Development Residential Pod H within the Baywinds PUD Master Development Plan, located at the northwest corner of 328th Street and 142nd Avenue, is legally described in Exhibit A and providing for an effective date.
Are there any questions from council?
No questions, Mayor, from me.
This is a public hearing. I'll open up the public hearing on item 9, 10, 11, and 12. Seeing none, close the public hearing. Final comments. Is there a motion?
I move it.
Is there a second?
I'm sorry, wait, Mayor. On tab 9 and tab 10, staff would like to add a condition to the resolution, which provides that the applicant shall submit final revised declarations consistent with the opinion or title, subject to the city attorney review and approval within 30 days from the effective date of the resolution. And that's just a housekeeping item.
Okay.
There were some minor changes with regards to the declarations that match these documents, and so we just like to memorialize it in both of these resolutions.
Problems with the maker of the motions?
Wait,
no.
Make a motion.
There was a
Yeah,
motion.
I'm on it. Yeah, I did. I withdraw my motion. I yield.
Yeah,
Can I
this is the
yield
first
to?
I hear of this, because I've been in contact with staff
Okay.
all day. So this is the first time I hear about
Ms.
a
Fairclough?
motion to add something. Have you spoken with the applicant?
Yes, we have.
Yes.
Have they spoken? Okay, because I like to be clear on everything that's happening with these items, so I was kind of blindsided
Yes,
by that.
if I may, Alex Arias, Holland and Knight, 701 Brickell Avenue. We spoke with the city attorney earlier today, and the only thing that happened is there was a small discrepancy in the opinion of title. They didn't add the Baywind CDD as an owner on the actual declaration items. So that's the only thing that we would have to add into the declaration items on C and D and E before we record. That's the only ministerial action that's necessary, but everything else remains the same.
Okay, I just wanted to make sure. I want to know everything when it comes to this, so, okay, I'm fine with that.
Mayor.
Mr. Williams?
So it's basically a scribble error, or?
Pretty much, a ministerial little task, a discrepancy between the opinion of title and the declaration documents. That's the
Okay.
only-
Then I make my motion again, Mayor.
All right, sir. Was there a second?
Second.
Is there a second? Any final comments? Roll call, Madam Clerk.
Councilman Maldonado,
Yes.
Councilman Burgess,
Yes.
Councilman Williams.
Yes.
Councilwoman Fairclough.
Yes.
Councilwoman Wallman,
Yes.
Vice Mayor Shelley,
Yes.
Mayor Porter,
Yes.
the motion carries.
Tab 13.
Tab 13 is a resolution of the City of Homestead, Florida, approving a request to vacate a public right-of-way on the south 25-foot portion of an approximately 2.6-acre parcel located at 1560 West Maury Drive, and reserving to the city all rights over any needed public utility easements as legally described in Exhibit A and providing for an effective date.
Report from staff.
Yes, sir. We recommend that the mayor and council approve this request to vacate the right-of-way. Back in 1973, a right-of-way deed was executed with the previous property owners and subsequently recorded granting the property use as a public right-of-way. We determined that this right-of-way is no longer needed by the city as part of the city's roadway network, and we are recommending approval to vacate it.
Questions from council? This is a public hearing. You're welcome to come at this time. Seeing none, close the public hearing. Final comments from council? Is there a motion?
Move it.
Moved and seconded. You get that, Madam Clerk? Ms. Wallman and Mr. Williams.
Councilman Burgess?
Yes.
Councilwoman Woolman?
Yes.
Councilwoman Fairclough?
Yes.
Councilman Williams?
Yes.
Councilman Maldonado?
Yes.
Vice Mayor Shelley?
Yes.
Mayor Porter?
Yes, tab
Motion
14.
carries.
Thank you.
Tab 14.
Mayor, that concludes your your quasi-judicial items. Moving on to your legislative items. Tab 14 is the second reading of an ordinance of the City of Homestead, Florida, amending the City Code of Ordinances by amending Chapter 28 Utilities, Article 7 Electricity, Division 7 Net Metering Program for customer-owned renewable generation systems, add Subdivision B rate schedules by amending Section 28431 Insurance to revise insurance requirements for renewable generation system customers, providing for inclusion in the code, providing for severability, providing for conflicts, and providing for an effective date. This is second and final reading.
Any report from staff?
Mayor, staff recommends that the mayor and council approve the motion.
Questions from council?
Yes.
Mr. Williams.
What is the major intent of this? I see tier 1 residential, so what are we saying that, what's the real intent of this?
The intent is to remove a somewhat onerous insurance requirement for residential customers who want to hook up to the electric grid because they have renewable generation such as solar panels. And previously, there was a stipulation that Tier 1, which are the small customers, that they had to name the City of Homestead as an additional insured on their insurance policy. And that's something that most residential policies will not do.
I got you. So we're removing that burden from the customer, from
Correct.
the residential part. Okay, I'm good with that.
Okay, this is a public hearing. I'll open up the public hearing at this time. Seeing none, close the public hearing. Final comments from council. Is there a motion?
Move it.
Moved and seconded?
Second.
I got it. Roll call, Madam Clerk.
Maldonado?
Yes.
Councilman Burgess?
Yes.
Councilwoman Woolman?
Yes.
Councilwoman Fairclough?
Yes.
Councilman Williams?
Yes.
Vice Mayor Shelley?
Yes.
Mayor Porter?
Yes.
The motion carries.
Tab 15.
Tab 15 is the first reading of an ordinance of the City of Homestead, Florida, amending Chapter 22.5 Retirement Plans, Article 2 Police Officers Retirement Plan, in accordance with the collective bargaining agreement between the city and the Dade County Police Benevolent Association for a period October 1, 2014 through September 30th, 2016, by amending Section 22.521 definitions to revise the definition of average final compensation, providing for repeal, providing for severability, providing for inclusion in the code, and providing for an effective date. This is first reading.
Staff report, Mr. Manager.
Mayor, staff recommends the mayor and council approve the attached ordinance.
Questions from council?
Move it, Mayor.
Is there a second?
Second.
Okay, I'll open up the public hearing at this time. Anyone like to speak? Close the public hearing. Final comments? Roll call, Madam Clerk.
Councilman Williams?
Yes.
Councilman Maldonado?
Yes.
Councilman Burgess?
Yes.
Councilwoman Woolman?
Yes.
Councilwoman Fairclough?
Yes.
Vice Mayor Shelley?
Yes.
Mayor Porter?
Yes.
The motion carries.
16.
Yes, Mayor. Tab 16 is a resolution of the City of Homestead, Florida, accepting a right-of-way deed conveying title for right-of-way purposes from Equality Development, Inc. to the City of Homestead and providing for an effective date.
Staff report.
Yes, sir, we recommend you approve this. This is kind of a ministerial action. We noticed in the plating for the Family Dollar, we needed a 25-foot radius that we needed to have accomplished at the northeast corner of that property. Pretty small thing, but we need to come for approval. We recommend approval.
All right. Questions from council?
Yeah, this is just.
Mr. Williams?
Yeah, thank you, Mayor. I'm sorry, I gotta use this button.
No, I got you.
Okay. How many Family Dollars do we have in Homestead? I think I have at least 3 or 4 in my district, at least. How many?
I haven't kept count.
It's a lot, right?
I don't know.
I mean, at some point, when do we say enough Family Dollars? I mean, I know this is not, but this is a question. I'm just.
I know one thing.
They're about like charter schools.
Don't wake that up.
Yeah.
Funny thing-
I'm just saying.
One thing is they're always packed though when
They
you go
always
into it,
pack.
so.
All right, I move it, Mayor. I'm sorry.
Is there a second?
Second.
Did I open up the public hearing? Madam Clerk? Did we open up the public? All right. This is a public hearing, tab 16, right away granted to us. Close the public hearing. Final comments? Roll call, Madam Clerk.
Councilwoman Fairclough?
Yes.
Councilman Williams?
Yes.
Councilman Maldonado?
Yes.
Councilman Burgess?
Yes.
Councilwoman Woolman?
Yes.
Vice Mayor Shelley?
Yes.
Mayor Porter?
Yes.
The motion carries.
17.
Yes, tab 17 is a resolution of the City Council of the City of Homestead, Florida, recognizing the month of April 2015 and each April thereafter as Sexual Assault Awareness Month in the City of Homestead, providing for implementation and providing for an effective date.
Ms. Waldman?
I'm going to move it. Hopefully I'll get a second.
Moved and seconded. Anything from staff? Just go for it. This is a public hearing. Anyone like to speak for or against? Close the public hearing. Final comments? Roll call, Madam Clerk.
Councilman Burgess?
Yes.
Councilman Maldonado?
Yes.
Councilman Williams?
Yes.
Councilwoman Fairclough?
Yes.
Councilwoman Woolman?
Yes.
Vice Mayor Shelley?
Yes.
Mayor Porter?
Yes.
The motion carries.
Reports from the manager?
Hey, there's just one thing. It came over the email. Many of you may not have seen it, but there was, I'll just read it from Major Kennedy. And Major, if you have any updates to this, units are presently on the scene of Little Caesar's Pizza located at 2854 Northeast 8th Street, investigating a traffic accident involving a vehicle that drove into the business. Initial information has identified 10 victims with injuries, none of which appear to be serious. The victims range in age from early 50s to 4 years of age. So, Major, anything else?
Anything new, Major?
I'm getting a call right now. If you can just give me a couple minutes, I'll be able to report back to you.
No.
Okay, that's it, Mr. Manager. Mr. Attorney? Anything?
Nothing at this time.
Reports from Mayor and Council. Mr. Williams? Thank you, Mr. Williams. Ms. Fairclough?
Yes, I just wanted to ask everyone to save the date for May 21st, 6 to 8 p.m. We're having a Champions for Education dinner and reception at the Homestead Miami Speedway Champions Club. I would like all of my colleagues to be there. City manager and staff. It's going to be a big night to talk about education, our end-of-year report. So May 21st from 6 to 8 p.m., Homestead Miami Speedway Champions Club.
Thank you, ma'am. Mr. Burgess?
Thank you, Mayor. A couple quick things. Mr. Cordino, several months.
Yes, sir.
Maybe even more than several months. We've been working on an abandoned guard shack in the Park of Commerce. Where are we at?
Well, we've identified that the guard shack is in the public right-of-way, and now we're double-checking to make sure we've identified that it is an unsafe structure. Just double-checking to make sure that we don't do anything we're not
So
supposed
we're
to
making
do.
progress.
We are inching closer to
certainly-
demolition.
I certainly appreciate you getting rid of that eyesore for us over there. Julio, a quick thing there, because we're coming up on 8 months since we were promised a light at Pacific Boulevard in Kingman. And I know that we were having trouble with the CDD, but supposedly the CDD signed off several months ago. Where are we at and when are we going to start?
Well, actually, last we spoke with the county. They still haven't received the agreement from the CDD to move it forward for their commission. So they're working on that. As soon as they have the money, they're just waiting for that one item so they can put it on the board.
Okay, so maybe I could reach out to Councilwoman Fairclough there to push the CDD along, because that's the only thing that's holding up that entire project over there. And I had thought that they had taken care of it, so thank you, Mr. Brady,
Design is
for that.
complete,
Yeah.
and they're just waiting for that.
And then to Chief, I think Captain Kent went home, but this week I received a disturbing email, as I think everybody did, if you looked in your junk mail. There was a house in Oasis that's being rented out, rooms, and it seems like there's a long process to get it taken care of, yet the neighbors are being affected by this each and every week as the gentleman rents it out, kind of like a hotel, to tourists. So I know that Crystal from Code Enforcement and Captain Kent and Major Kennedy and the chief, I passed it along to them and to the manager and to the attorneys. But we need to come up with a quicker remedy than giving this guy a citation and hoping he's going to show up at the next code compliance hearing, master hearing, and that. So I guess my question really is to James, because code compliance is doing what they're allowed to do. But what do we do to protect the citizens that live there and that are affected by this on a daily basis, as was described? I think you were somewhere in the chain of letters also. Because to me, that's disturbing that somebody, one, doesn't have the courtesy to respect what their neighbors have, and then two, that we don't have the ability to enforce with teeth and make them stop from doing this, which is obviously an illegal activity.
Well, couple of things. I provided your staff between last night and today information concerning the city's ability to enforce. These are considered vacation rentals or...
Well, how's it a vacation rental if the gentleman's living in the house with these people? But yet charging them and renting it on websites. And in the original email, there was 6 or 7 websites that the gentleman was listing.
Yeah, I'm not sure. Factually, I'm not sure. The leasing of any single-family residence or residence for any length of time below 30 days or 1 month is deemed to be a transient public lodging establishment under state law, and specifically a vacation rental. And in 2011, the Florida legislature preempted local governments with regards to your ability to prohibit vacation rentals in residential zones. That caused huge concern across the state and is a big issue for many communities. There was legislation that was proposed in years after. Nothing really made it out of committee or got adopted. Last year in 2014, the lobbying efforts on behalf of the vacation rental and hotel industry were successful in further infringing upon your home rule power, and went on to say that not only are you prohibited from not only are you not allowed to prohibit vacation rentals, but you're also not allowed to regulate the duration or the frequency of those vacation rentals. What you are left with is regulations that you can apply: noise, parking, health, safety, fire, those types of things, housing occupancy standards, all of which you have in your toolbox now that you can apply with regards to code enforcement. The one issue is failure to receive a business tax receipt, so that's an issue that will have to go to code enforcement, and all these vacation rentals are required to register with the state and pay bed tax as well. So,
So there are some remedies.
There are some remedies that...
It's just not it's not an instantaneous thing.
Correct. And the very nature of those vacation rentals are very hard to capture some of those types of violations.
Okay. Well, so we're looking at it. Chief, if I could I know they went out there and visited the home, I think yesterday, according to Crystal. If we could maybe get some sort of update as to if they were able to contact the owner again and where that stands, I'd appreciate it.
Excuse me, John. Question. The address, location, what community is this in?
It's in the Oasis neighborhood.
So
I can't remember the exact, right.
So
It's an ungated community.
Is it under an HOA? Is it under a HOA? Yes. So.
That's a tool. The HOA has been trying, I know that code enforcement's made several visits to the home, but citing the gentleman and getting him to show up and getting him to stop is a different thing.
The HOA has, and I know we've had this in our community before, and there is, you have to have a certain amount of months that you're going, if you're going to be using the house as a rental, it has to be a certain amount of months, more than 6 months.
And they have that in place over there, but this gentleman refuses to abide by their HOA docs, so.
So I guess that would have to be for the HOA to legally move against that, so I guess that would be the question.
One last thing there. Dennis, I noticed coming down 137 the other day, and I know that's a county highway and they're right away and median and all that, but I don't know how we go to them, because after the windy days, there's so many palm fronds that fall down out there that it makes it a hazard sometimes for the cars that are passing. So I don't know if maybe you could make a call to their department and just, have them maybe, and I understand that they're on every 3rd week or 4th week, whatever it is, but just maybe stress to them that with all the falling palm fronds, it's a hazard driving out there, and I'd hate to see somebody get hurt. So if we could just relay that to them, I'd appreciate it.
I sure will, Councilman.
Thank you. Thank you, Mayor.
Thank you, Mr. Burgess. Ms. Wellman?
Yes, thank you, Mr. Burgess, for bringing that up about that house, because I didn't see it in my spam. But I will tell you this, that when we have several of these in the villages that I've had complaints over the years, where people just rent out rooms. Like, for example, if they're having an outage at Turkey Point, you know, they may have 6 people living in their house, or 4 people. It's happening in Fairways even. I mean, it's happening everywhere. When I called code, I was told that rooming houses, chief, weren't allowed, and that's what they classified. That's what, when I called, it's been a while, rooming houses. So maybe we could differentiate between rooming houses and vacation rentals. You know, I mean, it's not a problem if you have a, you know, you're a single person or whatever, and you want to rent out, you know, you want a roommate. But when you start getting 4 and 5 people renting your property, that could be a problem on a nightly basis. Okay, I'm going to go fast because we've been here a long time and I've had a long day. Relay for Life is Friday night. As a cancer survivor, I beg you to come. I beg you to come and stay a while. The city has a team, and we're going to knock them. I think our team name is Cops because it's movie themed, so we're cops. I don't know where I'm going to get a uniform in the next 3 days, but I'm going to be a cop. I'll be undercover. And so I'm asking you all to come. We had an alligator sighting in the villages of Homestead. We set traps. It's there. He says hello. I mean, we know he's there. He disappears one day. But the problem is that it's adjacent to Audubon Park, a city park, and it's alligator season. So I caution everybody, when you're out and about in your community, and as the commander back there shaking his head, when you're out and about, let me tell you something. Those things are aggressive, and people are feeding ducks and feeding things around the lake, and they'll come out and kill your dog, baby, or grab your leg. I mean, they're awful. So I'm asking you all to be very aware that there could be an alligator in those lakes and ponds within your community. I wanted to thank Julio. Thank you very much for, we had a terrible accident where a trailer derailed from a truck in the Audubon Drive, and the stop signs were down, and I didn't know it. And then all of a sudden I saw it, and I don't think they were down a couple of days, but you got them right up, and I want to thank you for that. And also, Mr. Burgess has addressed this before, but that intersection at 162 and North Canal, I don't understand why the county put turning lights going, is it north and south, but they didn't put a turning signal going east and west. And just one time I was on the phone with Mr. Gretzis, and he saw an accident right in front of us happen. You know, I mean, it's so dangerous. And with the school there, Ms. Faircloth, I mean, it's very dangerous because you have, you know, it's a traffic nightmare at certain times of the day, and you don't have a turning signal. So maybe we could all help to do that. And I'm going to say happy birthday, Ms. Faircloth. And I have you a little something here. And I'm done. Thank you.
Mr. Maldonado.
Thank you. Just one question to Chief Roll. Hey, Chief. Has there been any concerns or anything in regards to the moving of the new police station from the community? Have you heard anything? Also to the city manager, maybe. Has there been any concerns, cares, complaints, anything in regards to that? It's been a good move, hopefully. I'm just inquiring.
Everything's been fine. They want us to stay, but we can't.
Okay. That's good. I just want to know. I mean, it's a new neighborhood. You know, we always wondering what's going on over there, and
we had a little roaming in the beginning, but the people love us there. As a matter of fact, there's more traffic out there, and people coming out there running and bringing the dogs out there. It's unbelievable.
Yeah.
And on top of that, believe it or not, we're getting more people coming to the station than we had in Oklahoma Avenue. Well, I was going to say that, but you're 100% correct. They can park.
Good. That sounds
Other
good.
than that, though,
That's it.
everything's
That was just
fine.
a question, see how you guys are doing over there.
And thank you all so much because, now we can park and breathe.
Excellent.
Vice Mayor?
Just one quick announcement, that's on May 30th, we have Military Appreciation Day again this year. It's the same kind of format as the last couple years that have made it so popular with the static displays and the food vouchers for the military. One of the things we've added new this year that's going to make it even more exciting is we actually have a military competition amongst all the tenants on the Homestead Air Reserve Base. So there'll be 12 teams. They'll be competing in an obstacle course, which includes a Hummer pull. It includes a rock wall climb, a push-up competition. All of that together, and the best team wins. They get a trophy for bragging rights, which will go on for the future, as well as a like $1,200 cash award. So it'll be a lot of fun. It should be a lot of fun this year. So put it on your calendars, May 30th this year, Military Appreciation Day. That's all, Mayor.
Thank you, Vice Mayor. I'd like to ask a request to appoint Eric Zuniga, how'd you say? Zuniga Mejia to Homestead Housing Authority Board. We had one resignation of someone. Moved? Is there a second? All in favor? Thank you. Julio, I'm going to ask again. I get so many complaints about the signalization and the length of time that the lights are open and the just unbelievable backups. 15th, 8th Street. I know we've been talking about this, but we've got to get somebody down here to talk to us and explain to us or prove to us that they can't do something better. I know you don't control the traffic signalization, but every intersection is just overwhelmed. So there's got to be something that they can do to improve that somewhat. So can you please get someone down here to talk to us or explain to us something about that?
Not a problem.
And the specific light in general, when where finance is, there's a light there.
Yeah, right. The first road, right?
First road. It's pointed wrong. You have to really, you're actually in the light before you can see what the light's
Yeah, and
color
we
is.
have brought that up to the county's attention. The problem with that light is, from what they tell us, is that it's so close to the one before it that if it turns green, people will actually, if they see it too early, they'll think that that light is working for the intersection that they're about to cross, and it creates a safety condition there. But they tried different ways of, like you said, pointing it in different directions so that the people don't see it as green right, before they should. It's just a matter that while you're driving, you're seeing beyond the traffic signal that you're at, because the other one is literally like 200 feet behind it, it's like right there. Well, and that's the issue.
I'm complaining. Yeah. I'm complaining.
No, and absolutely, we brought it up to their attention several times, yes.
Just a question. I know that there was an issue back where they're both past assistant city managers ran that light and got ticketed as well. Did they take that camera offline?
I'm not aware one way or another. That's.
Are we still ticketing folks for that light?
Yeah.
That's right next to the community bank. Is that the one you're
Yes.
talking about?
Yes.
According to the police, it's still operating. Yes.
Yeah, it's a problem.
Yeah.
It's a real problem. The last thing I'd like for us to talk about as a council is, as we vacate the old police station and all that surplus parking that's in the back, as soon as we can we revert that into public parking to facilitate some of the activities that could go on downtown? I know we've got vehicles over there, but at some point in time, why can't we use that for off-street?
We can give you an analysis and we can give you some reasons why we think maybe that's not a good idea.
Well, let's talk about that. Okay, just, as a future discussion item, as to the pros and the cons of putting that back into some sort of public use. Okay? I'm good. Is there a motion to adjourn?
Motion.
Second? All in favor? Meeting adjourned. Thank you.